All right, folks, we're going to get going here. Just a few ground rules. As you notice from the emails and the website, the purpose of this meeting is for primarily licensing staff and also for counsel's office to just go over some of the protocols and procedures and some of the issues that they're having, to be honest with you. There will be an opportunity for questions and answers, either at the end of each segment or at the end. Just want to note, since both Commissioner Fan and Chairman Bradley are here, this is not an open meeting, so there cannot be any discussion of anything that's going to be pending before the members of the authority. All right, so if you have some question or a concern, please keep it generic and not specific to an application. With that,
Can I see me up front?
yes.
So I want to thank you all for coming, and everybody in Albany and Buffalo. I'm going to tell you who's here. For those of you who don't know, this is Commissioner Fan. This is Lisa Ogden, who's with our counsel's office. This is Maureen Hughes, who's with licensing. Amy Mail, who's with licensing, who will mostly be doing the presentation today. Both of them. Adam Roberts, who's the Deputy Commissioner of Licensing, and Gary Meyerhoff, who's our new counsel. And I'm sure everybody knows Tom. I don't want anybody to think that we're doing this to criticize you. The reason this came about is because obviously we are having longer processing times over the last several months, as I'm sure you're all aware. We have been examining them, myself and Sharif Kabir and Adam, on a daily basis to see how we can become more efficient. We've been going through every process. We've been adding people as quickly as we can, and we have added people over the last few weeks, and we're going to be adding more over the next couple of months that are going to be examiners for licensing. But during this process of examining all of this, actually speaking with Amy and Maureen, we discovered that there's a lot of things that we see constantly from the industry that hold up our applications. There are errors that are common, that are really easy for you all to fix before we get here. Before the application gets to us. So that's really what the genesis of this is. We're not here to blame you for what's going on in our agency. We are looking inward, and that's how this came about. So hopefully you'll get something out of this. I do want to discuss two things before I turn it over to them. One, I think you probably all noticed, or if you haven't, check our website. The applications are now being sent to Philadelphia. The reason for that is nothing has changed here. This is a contract that the Comptroller's Office of the State of New York has had with Wells Fargo for several years. Wells Fargo changed their processes, and they are now processing these applications. And the only thing they do is basically open them up, take the check, deposit it for us, and then send the application to New York. It's not going to add any time to the application, we're told, but that's the reason it's going to Philadelphia. It has nothing really to do with us. It's not even our contract, but that's explained on the website. I know that's creating quite a buzz, and I think that just went out last week. The one thing that I do want to discuss briefly is the attorney self-certified. During this whole process of examining these processes, I have come to learn, as Sharif has come to learn, that the self-certification program as it stands is not helping us at all. And I think that Amy and Adam and Maureen will tell you the same thing. In fact, Amy's the one who told me. Upwards of 80% of the self-certified applications we get, and probably more than that, have major issues in them. And I'll give you an example of a major issue in my book. If a lawyer is self-certifying an application, and that application comes in and tells us there is not a church or school within 200 feet of a location, and a cursory review by Amy discovers that there is a church 200 feet from a location, within 200 feet, not even 300 feet, that's ridiculous. That application then goes on top of the pile at the back end of the normal applications, and that, to me, is something that if you're a lawyer and you're certifying something, that means you didn't even go to location and check. All you have to do is walk around the block. And that's the type of stuff we're seeing on self-certified applications. I have decided with them and the other people in the agency that we're not going to end this program, although I think most of the people that have to deal with this on a daily basis would like to. I am asking that it improve, and we're also going to become much stricter as far as errors on these applications. Right now, I know that that the rule was, and Amy, correct me if I'm wrong, the rule was you get one warning when there's a cursory review and we find a major error, and then the application goes into the normal pile. And then on the second time, you get a 6-month suspension from the program, and a third time you would be permanently expunged from the program. I don't believe that that's been happening. Am I correct in that?
We've gotten less on that.
And we're not going to get lax. We're going to get stricter. So this is either going to sink or swim on its own, is the way I look at it. So you'll either all be expunged from the program in a short time, or the applications will improve. The other thing I want to add on that is I know for a fact, as I see it, that attorneys, some attorneys, I'm not saying all attorneys, but some attorneys are certifying applications they did not prepare. Meaning that a representative is coming to them, giving them an application, paying them a fee to certify the application. If I see that, and it's very easy for us to figure that out, you're going to be permanently expunged immediately, because that's an application you are not preparing. And I'm not talking about a paralegal in your law firm. I'm talking about a representative or somebody else who does this for a living, who is coming to you to certify an application that you did not prepare. And I think that the reason for that is self-evident. With that, I'm going to turn it over to Adam briefly, and then I have Maureen, and I think you're going first.
Sure,
yeah.
do it.
And then Maureen and Amy. But thank you for coming. I appreciate it, and I just want to reiterate, we're not here to blame you for any of this. We're just trying to improve it. That's all.
Thanks, Chairman. So as Chairman mentioned, my name is Adam Roberts. I'm the new Deputy Commissioner of Licensing. Obviously, I took over for Jackie Held in May, June of this year. We just want to talk about some things, I guess, that are slowing our process down and trying to help everyone here understand about how, and the quality of application that you're putting in impacts the work that we're doing. So obviously, as the Chairman alluded to, we're looking at our own internal processes and procedures. We understand that there's things that we need to adjust on our end, either to become more consistent or to make things flow more efficiently. But we really want to discuss some things that are slowing us down. I'm going to talk about some major points. I'm going to leave it to Amy and Maureen, as they're more daily in the trenches with things, to discuss, to go over some high impact areas that we need to focus on. First thing I want to talk about is the licensing info mailbox. I'm sure everyone is aware that the licensing information mailbox exists. We get upwards of 150 to 200 emails daily into that mailbox. I want to let people know that there's other avenues for asking questions to licensing. In the Contact Us page on our website, there is other areas that you can ask questions to. Licensing info shouldn't be a catch-all for everything. So if you have wholesale questions or renewal questions or permit questions, we do have separate mailboxes set up for each one of those units that you can address questions to. Speaking with a lot of people in the room, I'm sure some people have already heard it from me, but I'll send out emails asking people to do their due diligence before they ask questions to the info mailbox. A lot of times we get questions in the info mailbox that are basic, that are very simple. What am I allowed to do under my on-premise license? And a lot of times I'll send an email out saying, please go do your due diligence and look through the ABC law. As practitioners in the industry, we're asking you, when you're representing clients, to go out and do some research, do your due diligence before asking us a question. If you have legitimate questions after that's done, we have no problem answering them. But the reality is that mailbox is monitored by our supervisors and the examiners doing applications. So as you can imagine, with 150, 200 emails, if they're sitting there answering questions about a lot of basic things, or even just taking 3 minutes to reply to an email that's very simple, if you do that 20, 30 times a day, we're talking an hour and a half, that they aren't spending time reviewing applications. The chairman mentioned we are working on processes to get more examiners into place because we realize that's where we're lacking. We need more people reviewing applications. I'm sure some of you noticed recently our serial date times are down. So it used to be 5-6 weeks that we were looking at from the time of application from mailing to getting a serial number. That number is down close to 2.5, 3 weeks at this point. We put other people in place to work on that intake process. But on that lines, some of what slows us down is the intake process being incomplete. So we'll get applications from people that are missing money, where the wrong community boards are notified, where the address is incorrect on the application for where you're applying for. And these are all things that we're relying on people in the industry to check on and make sure they're correct before submitting to us. Again, we're looking at our own processes, but we're asking that you look at your processes too to make sure that information coming to us is accurate and complete. It may not seem like a big deal when, the address is missing or something is incomplete, but all these minutes, based on the volume, the thousands of applications, and that's just new applications, never mind permits, renewals, and everything else that we receive, add up. And based on our resources and the people that we have, it really impacts what we do on a daily basis as far as examining, intaking, and getting letters out to people. I want to touch on deficiency letters because it seems to be that there's many cases where we're sending deficiency letters out multiple times. That is something that I've asked our examiners to stop doing, because every time that we have to sit down and write a deficiency letter, it takes time out of their day, especially if it's issues that we have asked for and we're getting either the same answer or not an answer at all. To me, that's a huge issue because, again, it takes time for them to sit down and write these deficiency letters, and then we have to have somebody process them when they come back in, and then they have to be reassigned to examiner for review. And if we're doing that 2 or 3 times on one application, you can imagine just how much that slows our process down. So anything that you as an industry can do to be responsive to our letters is very helpful. I'm working internally with our folks to make sure that the questions that we're asking from you are clear and concise, so we don't have to keep going back and forth about misunderstandings in the process. So that's something that we're working on, but I'm asking that you as an industry focus on getting that stuff back into us timely. Because along those lines, as you know, we'll disapprove applications for a failure to comply. So if you don't respond to us within 10 days, we'll disapprove the application. We're finding that a lot of people are using that opportunity to get themselves more time and then just request reconsideration after the fact because they'll get the information. That adds time to our process as well, and I don't think everyone understands that when reconsiderations come in, then we have to send it down to council, we have to get an opinion, we have to grant reconsideration, we have to retake the application back in, we have to reactivate it, we have to reassign it back to the examiner, they have to review it again. And these are all just time constraints that are killing us as far as us being able to look at applications in a timely manner. And obviously our goal is not to hold on to these applications. We want people to be open, we want people to be in business. That is our goal as an agency. But we need to do it fair.
That's efficient.
We lost New York City.
All right, I'll be right back.
Yeah, I certainly have no comment on that either.
Right.
Well, it's not a statement to go.
Can you hold on? Can you hear us in New York, in Albany and Buffalo?
Yeah. You didn't miss a thing.
Nope. So we were just talking about the self-certification program. As the chairman mentioned, we did take a deep look into that program itself and have found that we have on our end become a little more lax as far as allowing deficiencies on applications. I know over the history of the program, there's been some debate about what the purpose was and what it is. I want to make it clear that when an attorney is self-certifying an application, that we expect there to be no deficiencies on that application. The purpose of it for us is to put reliance on the information that's being provided to us by a representative or attorney so that we can then say, with little review, that this application is good to go. We are finding that there are major things missing, very simple things from this application. And after a quick review, then we can say, well, we don't put reliance on its work. We're going to kick it back into the pile in the date that it was filed. And again, the chairman mentioned the one issue, but there's a lot of other small things that are just missing on there. Basic information, complete pages not being filled out, and things like that is unacceptable for the purpose of the program. So again, we are going to be more strict on our regulating of that process. We do keep track now of attorneys who are compliant and non-compliant in the program. And again, if you are submitting applications that have deficiencies on them, you will be kicked out of the program. We are working ourselves to evaluate and to make sure the questions that we're asking on the self-certification form to be clear and accurate so that we are getting the information from you in fairness to everyone. So that is something we're evaluating as well. But I just want to make it clear that the expectation is that when you're self-certifying applications, that there are no deficiencies on them. They should be clean applications, all the information accurate, complete. And again, at this point, we're looking at applications that are just missing pages, that are missing information, identifying basic things, that we rely on to make decisions. This is the bad news. As far as processing times, we are creeping up. So a few months ago, we had originally indicated that we were going to be at 15 to 21 weeks. We are getting closer to 24, 26 weeks as far as processing times. It is not ideal information for both us or for you, but we want to make everyone aware of what it is so you can accurately inform your clients of where we're at.
After mailing?
No,
What point? From the serial
from
date?
mailing.
From mailing?
From mailing. So from the time that your application is in the mail, the check clears, to getting a decision out the door, we're closer to 24 to 20 weeks as opposed to 15 to 21. Again, that's based on several factors. As the chairman mentioned, we are looking to get other people in place. We're looking at our processes to see how we can make things more efficient, speed that up. We understand that it's not ideal for anybody, for you as practitioners or for us as an agency, so we are evaluating that. We do have additional people coming in. Hopefully we're going to put positions where they are making impacts on the application process and our review times. But everyone just needs to know so you can advise your clients appropriately. With that, we ask that when you are representing clients, to make sure they understand what our process is. We appreciate when you, as representatives, insert yourself to actually represent your clients and not allow them to come to us directly. There are times when, our window upstairs, people are coming in every single day saying, my representative told me to come do this, pick up my application, when we're not anywhere at a point that's the application is ready to do that. So any information that you can share with your clients, the people that you represent, about our processes, and if that's unclear, feel free to reach out to us and we'll be happy to clarify. But anything that you can do to insert yourselves into those positions to make them aware of our times and our processes and how things flow helps us greatly because, again, people not at the window responding to people's customer service needs, which we're happy to do, allows them to be working on other things like getting your applications out the door. Amy, I'm going to turn it over to Amy Maureen.
Before you do though, I want to add one thing, and it really doesn't help you folks here in New York City, but it's more directed at the upstate people. We get recognizing where our processing times are, we get a ton of applications from outside of New York City that are not requesting temps. And I don't understand it myself. And frequently the answer I get is that my client doesn't have the extra money. Well, if you do the math, one, you're open. So you should be selling, so it shouldn't be costing you any more. But the other aspect is that the temp is 90 days, the first one?
Yes.
And
30 days for 3 after that.
No, but how much is it? 640. So 90 days, 640. If you do the math, it's the same amount or less than what your application fee is per year. And there is nothing requiring you to take your permanent application, should it get approved during the temp, before your temp runs. Meaning that if you're conditionally approved and you only have your temp for 30 days, you can wait the 60 days to come in and pick up your license. Your license does not start to run, your permanent license, until you pick it up. So run the entire temp and get your money's worth out of the $600 plus dollars, then come in the week before, pick up your license once the conditions are filled. So it just makes no sense to me, and I frequently get people complaining about the processing times, and our temps are being turned over in what?
7 to 10 days after serial.
After serial. So it makes no sense not to get a temporary license. And if your clients don't understand that or you don't understand that, then call us and we'll explain it again to you, because it really will alleviate a lot of the problems that you're having outside of New York City. I recognize it does not help you guys for the most part at all. But so that's, I just wanted to add that.
And so Amy's going to touch a little bit more on the STs and temporary refill permits. I just want to mention, though, that self-certified program, we are still processing those applications about 30 days quicker than we are currently on our normal applications. So if you are going through that process, you can expect to see a decision made on that within 30 days quicker than our normal processing time. So there is that benefit if you are self-certifying for applications. And again, on that point, whether it's self-certified or an application that you're putting through our regular process, I mean, our expectation is that there's minimal deficiencies that are required on that. Obviously, there are some things that you as a representative aren't aware of at the time. We do expect that the application that you are submitting to us at the time is both accurate and complete. There's a lot of cases where I understand in the industry, based on timing, that things change. I will generally say, though, our position is not to amend applications or matters of fact on the application while it's pending. And I know that's not the most convenient thing for clients, but for our purposes, we can't go back and continue to amend pages of applications and re-review information 2-3 times while we have one application working out. It doesn't speed up the process for anybody at that point. So with that, Amy and Maureen are going to talk a little bit about some of the more common things that we're seeing on applications. Hopefully we can address some of these issues going forward. Be aware that these are things that we're seeing that are common mistakes, but hopefully we can provide some insight on both why we're asking for these things and why it helps us process applications.
Adam, you want to take a question now, or you want to wait till it's all?
After everything's done, we will take questions. I do want to say that I would like to limit our questions to policies on certain things as opposed to individual specific comments. Yeah.
But it's just that, I'm going to forget. What you just said about the mending, that's the opposite of what we've been told at other meetings here in the past. We've been told that, and especially now if an application is sitting around for 6 months, there's going to be changes, and we were told, don't wait until the license is issued to file, to file a change. You're supposed to amend the application while it's pending. And you're saying don't amend the application while it's pending. Start all over again and wait another 6 months.
Well, and I guess Amy brings up a good point. I talked about what we're amending. We've had internal conversations about this because, to your point, I understand that there is some value in us amending certain things for that. But when we're talking about corporate structure changes that are different from the applicant principles and things along that nature, those are things that we can't be changing during the application review.
Well, an investor comes in, it's sitting there, new investor comes in with more money, than more than 10%. You want us not to tell you about?
That's not what I'm suggesting at all.
Also, but if the choice is not tell you about it or tell you about it, but we can't amend the application and it's got to start at the beginning of the process, what you're telling the industry is don't tell us about it.
That's not what I'm suggesting, that you file applications and advise your clients what the impact is if you're doing that. And so these questions right now, these kind of things, I don't want to get into in this forum. I don't think this is the proper place for it.
Sorry, that's absurd.
So if we want to talk about that, we can talk about things at the end. If you have questions like that we need to address from a policy perspective, I'd be happy to accept those via email and we can discuss them as a whole. But we're not going to entertain those kind of questions in this forum today.
Morning, everyone. So what we did was, first of all, I'd like to clarify something the chairman said on the new address for license applications. That has nothing to do with renewals. Renewals still go to M&T, just in case there was any confusion there. So what I did was I had my staff give me input on what they're seeing, repeated deficiencies that we send out letters on over and over again. So I just want to bring up a few of the items that they have provided to me. I'm going to go chronologically through the application. The very first page of the application where you're listing the email address, it should be the email address of the applicant of the premises, not your address. If they ever choose not to use you in the future, all their documents are going to be going to an attorney that's no longer employed by them. A clear organizational chart, when you have an applicant that has a bunch of holding corps or LLCs underneath that, we should see those LLCs listed and who is in those LLCs and the percentage of the ownership for those people. If it's a publicly traded company, you can just note that it's publicly traded. You don't have to go through and list anyone. On the second page of the application is where we list the principals. That is where our clerical unit obtains the information to data enter into our system. They're not thumbing through and looking through for the personal questionnaire and taking the information from there. So make sure that the information on page 2 is correct. You verified it, that you looked at their passport, you spelled their names right, social security number is right. We get a lot of emails and licensing information where we've asked for people to be fingerprinted when they actually are already licensed. That's because the name was misspelled or the social security number was wrong, and when clerical ran it, they didn't find anything. So therefore we asked for them to be fingerprinted, which was not necessary.
No, and just to add to what she's saying, you all are being paid to fill these applications out. The fact that you can't get the Social Security of your client correct amazes me. Take the card if you have to and read off of that. But that in and of itself slows our process up that you cannot imagine when you just get one digit off or you're not spelling their name correctly. It just amazes me that you're charging a fee and we're on the second page. And how often do you see that? Daily, correct?
I would say at least once a week.
I mean, it's amazing.
I'm finding that principals, now I know we're 5 months behind pretty much, are still not being fingerprinted when we go to pick up that application. You should be telling your clients that, hey, you get that receipt and it says you need to be fingerprinted, you need to go and get that done. And here I will give you an example of what happened just last week. The gentleman did not disclose that he was a felon in another state. So had he went and gotten fingerprinted 2 weeks in, he may have had the 3 months to get the proper documentation. Now we're at the approval stage, and, oh, he's got a felony. Well, do you have a certificate of relief? No, I don't. And everyone in here in this room knows it takes months to get that sometimes from the court. So it's really important that these people go out and get fingerprinted so we can take care of that early on. The right to premises. Your client does not own that property unless it is in the name of the applicant applying. They can own it under another corporation they formed, but that still makes it that you need a lease. So if the name on the deed and the name on the application does not match, we need a lease for that property. That happens quite frequently. The landlord identification. Very seldom do we get the landlord's home address. It's blank most of the time. And the reason why we want that information is because if I'm looking up James Hall in our system, because we have to run every name that we see in that application to see if they've been licensed, and there's more than one James Hall, it's going to take me a while to go through and figure out which guy could be mine. And if he could be mine, now I have to go check to see, has he been revoked, canceled? I mean, we check the history on everything, so if we really do need that home address for the landlords so we can verify whether they have a history or not with the authorities. Financial disclosure form. Large deposits need to be explained. You know, maybe it was an insurance settlement, whatever that case may be, we need to know where that money's coming from. I've seen a lot where we get one bank statement and there's a bunch of deposits, and look, they do have the $200,000. Well, that's really not the source of the money. The source of the money is coming from all those deposits. So we need to know what those bank accounts were. Where is the money coming from? Were they his other bank accounts? Were they loans? We don't know, so therefore we have to send a deficiency and we have to ask for it.
And that's something that I've seen we have to ask for 2 and 3 times. And I think the message here is send more in. Nobody's getting their hands on this. It's not foilable, these bank statements. So just send everything in rather than us sending 3 letters out.
All lenders, donors, and joint account holders must submit a personal questionnaire. That, I will say, that was a problem maybe a year or 2 ago. That's gotten better, but we still get people that don't submit those items. 500-foot statement. Make sure you're checking the appropriate box. A lot of people just check there isn't any. Well, there isn't any need for it because the population's under 20,000. Each time something comes in, we got to look up the population to see, did they catch that? Did they not catch that? So double check that. Public interest statements. We are getting applications without them. We no longer schedule 500-foot hearings without a public interest statement. If The application comes in, it just goes on its merry way until the deficiency letter. So now, if and when we ever do get caught up, you might hold up your applicant because now we've got to schedule a 500-foot after the deficiency's gone out, and that should be getting closer to the end of the process. You should not be sending the same general public interest statement with every application you file. I've seen it. I've looked up somebody's applications, same exact sheet of paper in every single one. I mean, there's got to be something special about each thing that's being opened up in those neighborhoods. You got to have the first Italian place, the first Mexican place, something. The 200-foot law. If you are telling me that there is a church 146 feet away from the proposed premises, and you're telling me that it's not exclusive, could you please attach a statement and tell me why it's not exclusive? Did you already interview the pastor? How did you figure it out? Because I'm starting from scratch now when I'm looking at it. How did you determine that? Any kind of inference you can provide would be helpful. We're starting from scratch, trying to figure it out. It takes time. A lot of times I go to Google Maps, I put the little man down, and I walk around the perimeter of the property to see what's there, because I can't go to each place just to see if I can notice something. Is it in a plaza? What's the deal with it? The establishment questionnaire and diagrams. Outside areas need to be contiguous with the interior. You can't walk out the front door, walk down the sidewalk, and walk into an enclosed area that has no way of getting inside. People need to be able to get to the outside area from the interior of the premises. You can't walk on a public street to enter into it. You can't have one across a sidewalk into a little grassy area. That's more common upstate than it is down here. But everybody needs to be able to walk right out and empty right into the contained area. Any outside area should be depicted on the diagram for the floor that it's on. So a sidewalk cafe would be on the ground floor diagram. A second floor terrace would be shown on the second floor diagram. For some reason, people don't add any outside areas when they send in diagrams. If you don't disclose an outside area to your community board or your municipality, don't put it in the application unless you've already obtained a letter from the CV that they acknowledge that there will be an outside area and they're okay with it. We're going to kick it back in a deficiency letter and say you either need the letter or you need to remove it from the application. Diagrams should show any doors. It should show where the bars are, where the kitchen is, where the food prep is. Measurements would be helpful. I won't kick that back for no measurements as long as I can tell from the photos. Basically the scale of the room, because obviously an 8.5 by 11 sheet of paper doesn't give you the scale. Architectural drawings are very difficult to read. They're a nightmare. So if you can avoid those, please do that. I'm not an architect. Staff isn't an architect. And they put way too much information in there, down to what kind of flooring is being used. I mean, you just don't know what half the stuff is on there. Block plot diagrams can't be Google Maps overhead. A lot of people just send that in thinking that's fine. That's not sufficient. Nothing's been labeled. Sometimes they're hard to read. I mean, if you're in upstate New York up in the Adirondacks and there's 3 buildings next to a restaurant, that's one thing. But down here, it's impossible to use those. Restroom waivers. They are required when there is not a restroom within the licensed premises. I don't care if it's around the corner from the premises, you're in a communal dining hall, whatever the case may be. If you don't have a restroom within your premises, I need a restroom waiver. You need to tell me where that restroom is, how far it is away from where your patrons are drinking and eating. Method of operation, same thing with the community board. Don't add things in after you've told the community board that you're not going to have a DJ and now your application comes in and I'm reading DJ on there. We're not going to let that go through. You're going to have to remove it or, again, provide a letter from the community board that they've approved it.
And just to add to that, we get a lot of that at the board. And you're going to get denied at the board if that happens, if it's inconsistent. Because that is, in my mind, a red flag that you're telling them one thing and then telling us another. So if it even gets that far, ideally it shouldn't, but if it does, that's going to end up in a denial.
Personal questionnaires. We require 5 continuous years, the last 5 continuous years of employment history and address history. A lot of times we're not provided with that. I also see a lot of just non-answered questions. Have you ever had a license? Blank. They don't answer yes or no, and they don't fill anything out. We need to know that information. A lot of times I'll let it go if they've had it and they didn't have any adverse history. But these questions really should be completed for the examiner. Temporary retail permits. Let's see. They should come in, if your client's applying for a temporary, they should have an executed lease that comes in with the application. We're going to require that. We're going to ask for that now. If you haven't seen one where we need to have that so we know that they can operate legally at that location. I see a lot where an application will come in and the foundation's poured or the place has got it and they have a temporary retail permit. There are a lot of times when people apply for them and they never, ever get issued. Maybe not now because we're 5 months behind, but when we get caught up, sometimes construction can go on or sometimes we get it done quicker. And now these people have paid for a temporary that they never get. They get conditionally approved, 3 months later, they get their permanent license. So if your client's not ready to open operate, there's really no reason to apply for a temporary. You can always do so a little bit longer down the road. You can send them into Albany and we can process them. You know, they've applied for 3 months. We haven't gotten to it yet. Now they're ready to open operate. Send in a temp at that point. They don't necessarily have to come in with the original filing. Temporary retail permits. If you are operating on a temporary retail permit and you get a conditional letter of approval, we're not going to give you an extension past the 6 months provided for in that letter. We're not going to let you operate for months on end if that ends. If your client does not have a temporary and they want an extension, we will extend it up to 18 months from the time they're approved.
That hopefully is changing though.
Okay.
Wednesday.
Okay. Check that. Temporary retail permits, where a 500-foot hearing is required and there isn't a transfer, we're going to wait on the ALJ report. So that temporary is not going to be issued until we get that from them.
I just asked a quick
Say that
question.
again?
You mean,
Yeah.
you said when it's not a transfer.
When it's not a transfer.
All right.
If it is a transfer, it'll be issued.
Correct. Right. Well,
The authority has,
we have licenses outside of New York City, though.
But they're not eligible for a
the authority has adopted a policy that the statute says that a 500-foot application, a new one, is not eligible for a temporary permit. That being said, the authority has, since that law was put into effect, adopted a policy that we will issue the temporary permit after the 500-foot hearing if there is no opposition on the record. So we're doing you a favor.
For new license.
Yes.
You do that in New York City too?
You don't get, it's not eligible.
So it's not eligible upstate either. You just interpret it.
But it,
That's what you just said.
yeah, I know what I just said.
So could you interpret the law that way for New York City?
Then you know what the result would be if we did that. So,
Yeah.
Would you rather us take it away from everybody upstate?
Places opening soon.
no. War.
Excuse me, what's the policy on extending the 90-day permits before the application of the permanent license is approved? How many extensions are we giving at?
If it's conditionally approved, they only,
Before it's conditionally approved.
until it's either approved or disapproved, we'll continue to issue the temporaries. Is that your question?
And how long in advance do the applicants have to apply for the extension?
I would say at least a week to 10 days before they expire. They should be sending in the next one. Yes.
Well, if
Excuse
you
me,
look at our-
Chairman.
Yeah.
We can't hear the question in Buffalo. Could you repeat the question before you get back to
Yes, the question was if you're conditionally approved before you open. Right now, we allow you to be conditionally approved and not open for 18 months. There's an advisory on the board calendar tomorrow that would allow us to extend that with the board's approval on a case-by-case basis. And that has to obviously be voted on.
Will it be retroactive?
We can't get into a discussion about that because it's on the full board calendar tomorrow.
So you allow extensions of terms after an application has been conditionally approved?
Yes, up to the 6 months.
6 months.
So the letter gives you 6 months to come and pick up the license. We're allowing them to keep the temps going for those 6 months.
After the extension.
Okay, 30-day notifications. I still have people, well, not necessarily right now, but when we get caught up, who don't wait for 30 days. They mail off the community board notification and they mail in their application all at the same time. Sometimes we were holding them if it was close. Then it got to be when we were caught up with data entry, I'm not going to hold an application for 3 weeks, waiting for the 30 days to transpire. So those will be disapproved once clerical gets caught up again. Leases. What information does the SLA require in a valid lease? We need the landlord name, the tenant name, and it must match the application. That's the name on the application. The address of the premises must match the premise address on the application. The use. What are we using it for? Grocery store, restaurant. The term, it should have a commencement date, or it should say from the time that the application is conditionally approved, issued, something, and how long will it run for. I need a monthly rent schedule. How much are we paying per month? There should be a default clause, and it should be signed by both the tenant and the landlord. Out-of-state arrests. Huh? What happens if they don't pay? Out-of-state arrests should be submitted with a disposition from the court and a letter from the attorney that advises what the equivalent conviction would be if the crime occurred here in New York State. Very seldom do those come in. But that should be something that we should be getting from the applicant when they apply. Photos are required at the time of application, regardless of whether they're ready to open and operate or not. Alcohol should not be shown in the photos if your applicant did not buy business from the guy before him. It's amazing how often we get applications where 9 months has transpired since somebody's operated there and there's a fully stocked bar. So we only can assume that they've been operating without a license at that point. We always need a photo of the food prep area or the kitchen. We're finding in New York City the wording on the newspaper affidavit, people are tweaking that. It should be what is on the section in the application. You shouldn't be changing that in any way other than the parentheses part where you're supposed to tell what your applicant's applying for. Corporate changes. Frequently, the percentages and shares listed in this section are incorrect for the principals we currently have. A lot of times we see that the attorney that originally filed the application is also now filing the corporate change. Why you don't know what the percentages or shares are, I'm not quite sure, but you should refer back to that application to make sure everything matches. If it doesn't match, you're going to get a deficiency. If all existing principals from the corporation are being removed and new people are coming on, we need a signed statement from those people stating that they're going to abide by the current method of operation that's in place. And this is for renewals too. If you're not sure you're taking over this file from somebody else, the applicants, this is the first time they're hiring you, you can go to our public query on our website, and you can look up who the principals are. At least you can have all that information. Same thing for renewals. You know, if you're not quite sure who's on the license, the information provided there is the exact same information that I'm going to see if I look it up for you. So that is a good tool to have and to know about. Alterations. You need to submit 2 diagrams, one beforehand and one what it's going to look like when it's all said and done. A lot of times we get one with everything on there, and then we got to figure out what's the old and what's the new. Can anybody tell me the most common renewal error? Signing a bond. Very seldom do people sign a bond. A lot of renewals get rejected for that, and it's just a matter of a quick signature, bottom left corner.
Excuse me, what's the authority's position on electronic signatures on applications?
Electronic, are you asking about electronic signatures? Yes. The new system will allow it, and we will allow it at this point. Class change applications and alterations. If you're filing a class change client, there's no need to file an alteration with it. If something's changing, you're adding a bar, you're adding an outside area, we'll take all that in at the time that the class change is filed. Just make sure that you provide us with the correct diagrams so that we can see that you're adding something new, and maybe provide a cover letter to that extent that we need to look for that something's being changed.
Can you say that again? So if we're filing an application for a premise already licensed, then we make minor changes to the floor plan, you can do it at the
You can do it at the filing the class change is enough. We'll take it from that. You don't have to file an alteration as well. Yes?
What's the turnaround period on class change?
They are the same as any other application. Method of operation applications. We get this a lot where you're filing it because you don't want to be a bar anymore, you want to be a restaurant. You don't want to be a restaurant anymore, you want to be a bar. That is not the application for this. Method of operations is to add music, dancing, security guards. That's all that's for. You can't change the class that you operate under by filing method of operation hours.
And can you just explain why you're talking about 2 licenses that are under 2 separate statutes? If you're going to go from a restaurant to a bar, we have to get a new application.
With regard to, I've been told, liquor stores, the change in method of operation application really doesn't, when you look at it, it doesn't apply to liquor stores. If I have some change going on in the liquor store, no manager to hiring a manager. Now, I understand, from the statute, notify the state liquor authority, provide them with a manager's personal questionnaire. Because there's a change in the application itself. I'm checking off no manager to manager. But again, and I've been told some time ago when I inquired about this, liquor stores really don't fit under the change in method of operation application that exists, which really is for on-premises licenses.
When it first started, we did have it used for adding internet sales. Whether Adam or the chairman want to continue that, or it's not necessary. Do you want to have them file a method of operation for internet sales? Manager, you can just send in a copy to PQ and
a cover
letter.
Yeah, explain the
stating that they hired
situation.
a manager. But if they're going to now have internet sales, they should be filing the method of operation.
Right. Okay, so most of that application is not applicable.
It's mostly for.
Yeah, I'm not answering 99% of those questions are not being answered.
Right. Correct, because you're adding just internet sales. I also see a lot of applications where we're getting duplicate documents, photos. Sometimes I get 3 sets. We only need 1 set of photos, 1 set of documents. I believe back in the day you were supposed to send sets. We no longer need that, and because of the storage for scanning things in, just 1 set of photos would be great. We're just throwing out the other set, so you might save some money there with shipping and with the photos. The abandonment process. We get applicants that ask once they file, the previous guy's no longer there, and you send an abandonment notice. That takes 2 weeks. If your client can get a letter from the landlord stating that ABC liquor store has moved out, they abandon the premise on this date, we'll accept that and we'll just inactivate the current licensee there. It saves your client time, saves us time, and it's immediate. If your client has not filed yet and you want to start the abandonment process, that is an enforcement issue. You should be contacting enforcement to go out and make sure that they're no longer operating there. I won't do anything with it at that point if we don't have a pending application. Make sure the copies you are making are legible and they're of a font that someone else can read. We've had a bunch of documents come in where I literally have to get my magnifying glass out to read it, and it shouldn't be like that. You should be making the copies legible. Also, we don't take double-sided. All our applications need to be scanned in, and it is a pain for somebody to constantly change over the scanner, and what happens is they don't change over the scanner when they should, so now you either don't get the second page, or now you've got a bunch of blank pages in there. Applicants should not be scheduling grand openings or accepting dates for private functions unless they have the license in hand or they have a conditional approval letter in hand and they know for a fact that they will be able to obtain that license before the date that they intend to open or provide a wedding venue for someone. We get a lot of calls and emails that, hey, I've got a wedding coming up October 17th and I don't have my liquor license. Well, you shouldn't be making plans to host parties or have a grand opening until you know that you can get that liquor license in time for that.
And on that point, I realize that most of you do advise your people of that. In fact, I've seen myself that you advise them of that, and frequently they don't listen to you, but I would just ask that you speak louder or whatever the case may be. But it really doesn't help the situation when that occurs.
The last topic I want to talk about is restaurants and taverns. I see a lot of applicants that apply as a restaurant, and then we have to switch them to a tavern after they've applied. Either they don't have a kitchen, or they don't have a menu that substantiates a restaurant. A tavern should be sandwiches, items like that. A restaurant should be more entree-like meals, not things that you put in between two slices of bread or a bun or a panini. The definition of a restaurant, it says right in the definition that the availability of sandwiches, soups, and other foods, whether fresh, pre-cooked, frozen, is not deemed in compliance with the requirement. They need to have substantial food, and sandwiches and paninis and wraps would not be it.
What about hamburgers?
That's questionable.
I think we have to, some of these things I think we have to look at by case basis just to determine what it is. I mean, generally, Amy's correct in our definitions between the difference between restaurants and taverns. I mean, I think there are some applications that lend themselves to be more one than the other, and I think it's, from a common sense perspective, we have to consider all of that the application and not just the menu itself, but generally, those are the expectations that we have when it comes to differentiating from restaurants.
Because given how difficult it is to reverse course, once we've looked at like a substantial hamburger menu and we consider it to be a restaurant, by the time it gets to you and you think otherwise, we've lost a lot of time. And it would be helpful if there was a way to speak with you ahead of time and
to that
give you a
point,
menu.
absolutely. I mean, I think any time that you have questions about the application that you're going to present to us, or if you have funky situations, because obviously we know those things happen all the time in this industry, come talk to us. I mean, I think I make myself pretty available so far to people I've worked with. Feel free to reach out to me. If you have a question that needs to be addressed, if you're not sure about something before you put the application in, shoot me an email, and I'll be happy to work with you on the situation to come up with a solution prior to that happening. Because again, going back to what we were talking before, we are trying to limit the amount of amendments and changes on these applications as much as possible because it slows us down, and it slows your clients down in the process down. So as much as you can, if you have questions about scenarios, things that you are iffy about, please send me an email and we'll work on a solution.
And that's been my message for the 4+ years I've been here, is that if you have a situation, and I can't tell you how many meetings I've had going through people's menus to figure out if they're a restaurant or not, or does this account for, do these microwavable pizzas, are they enough for a tavern? That remains, that policy remains. We are open to sit down, particularly, and I ask you to sit down, particularly on issues that are not clear in the law, because you're eventually going to end up sitting down with us anyway. And as Adam said, it's much better to do that before you apply, because maybe you can tweak something for us that will help us fit it into something that you hadn't even thought about. So we try to do what we can with the law as it is, and we all know what we're dealing with as far as what the law is.
All right, I'm going to turn it over to Maureen.
Quick question on that.
No. Sure.
Is there any disadvantage calling or getting a bar tavern as opposed to a restaurant if it's really a restaurant?
Is there a disadvantage?
It's costly.
Huh?
If you're not sure, if you just call it a bar tavern.
You can.
No, he's asking us, is there a disadvantage if you're not sure that you call it a bar tavern? What are you losing by doing that?
Interior access issues.
Right.
Yeah.
There are some statutory and regulatory prohibitions that apply to 64A, the bar tavern license, rather than the restaurant license under 64.
And the other thing that she just pointed out, particularly in New York City, is the minute a community board sees a bar, they think differently than if it's a restaurant. But that's stuff you guys have been dealing with much longer.
Just quick, on the, once you're filing a 30-day notice, and then you start the application, and over the course of the next several weeks, you realize, oh, he does want a DJ, or he does want live music. I've been submitting amended notices, but we don't have to wait an additional.
You don't have to wait.
Okay, it's just
Just quickly going on back to the financial disclosure. What is the authority's current thinking on an application with 11 or more investors, let's say 30 investors, and everyone is contributing some amount of money to the venture? Who do you want bank statements from?
Depends on the
Depends
type
on
of
the
corporation. If it's an LLC, we would need
You have 30 investors and
Yeah.
everyone's putting in $100,000. You want 3 months bank statements from everybody?
right? I mean, that's not.
That's not what I mean, because in the past there's been different cutoffs that we've been given.
Right, and generally it's not everyone's contributing the exact same figure.
Right.
It would be, we would look to see where the majority of the funds are coming from and just take the majority of the people.
But that being said, we're not going to know that till we're looking at the application. So to save yourself, I realize they don't want to give out their bank statements, but you're better off sending them all. It just means we're not going to look at the other ones.
No, it's fair. Just sometimes there's just such a volume that we don't want to inundate you with,
I don't think that's a concern.
Are you not taking the company's bank statements anymore?
Well, it depends on where the money's coming from. If it's coming from one company,
If it's the applicant entity.
okay, but like I spoke of earlier, is everybody funneling their money to that bank account and then showing us that one bank account?
Yeah, that's big. That's why
That doesn't give us any. I'm sorry, what?
It was outside.
Oh, that doesn't give us any information whatsoever. If it's just being funneled into a bank account and we have no idea where that money came from.
Are you hearing the questions up in Albany and Buffalo?
Yes. Are we hearing the questions, everyone okay? Yes. In Buffalo.
You may have an application where you could have an investment fund that owns a piece of the licensee entity, and they may have hundreds of investors that each contributed a small amount of money. We've never given all of that. So say, question that if they're 30 or 50, what if they're 100? What if they're 150? I mean, at what point?
We'd have to look to see how much is being used for the venture and see where the money's coming from.
I'm saying let's assume the majority may be coming from a small group, but you have 200 investors that are indirect owners that are each putting in $100,000. We've never submitted.
Well, at some point we do cut it off. I mean,
Right, well,
that's clear.
That's what I'm going at.
Yeah.
So-
Well, when
so
you've been doing this long enough to figure out when we do that. I think what she's saying is that we try to analyze until we get a majority, and then anyone under 10 we usually don't bother with. But if in the situation he's talking about with 30 that are all doing the same amount, how do we pick and choose? We can't.
Well, I mean, the reason I raise this is because if we are going to be removing applications from attorney certification for issues that are determined by the authority to be incomplete, I don't want to get an application back saying you didn't give us the amount of bank statements from people who you were supposed to give us bank statements for. When it's really a matter of opinion. in a complicated application.
It's not a matter of opinion, because it's whatever our opinion is what it is. So you might have a different opinion, but it's not really
Your
relevant.
opinion,
Maybe you don't
your
self-cert
opinion
that
is
one.
not clearly articulated.
But
yours
but
is consistent.
but the errors we're talking about in self-cert, we're not even close. You're not even close to how simple the ones we're seeing.
And I get that.
And I don't know that you would be thrown out for that. We're talking about the stuff, if I could show you that we're getting on self-cert, is so far removed from what you're talking about that we'll worry about that when they get that good, and they're not anywhere near that good.
But even what I'm hearing now is different from what was told to us at these other meetings in the past. We've been told that the authority came up with this arbitrary paperwork reduction number of 11 or more investors, if you will, because you didn't want reams of PQs and bank statements from people taking 1, 2, 3, 4% of a business. But now you're telling me, even if there are 20 people with 1, 2, there's like 2 people giving you PQs because they got 20% each, and they're putting
It's
in
two
money.
different. You've got two issues you're talking about.
No,
No, it's two issues.
I've got 20 people putting in money. They're each 1 or 2% each. Are you telling me now that you want 3 months bank statements from each of those?
Well, why don't you
2%?
tell us who should we take back statements from?
Anyone who is required to give you a PQ.
Okay, can
That's what the rule was, and that was simple.
So
if you're required to give a PQ,
Can he finish what he's saying?
Can you interrupt again? Sure.
Thank you. There's two different things we're talking about here. One is the finances. That's under one subdivision of 110. You're supposed to supply all the financial information. Separate from that is who's on the license, who has to file a personal questionnaire. That's where you get to the, if there's 10 or more stockholders, whoever has, 10% or more. So it's two separate issues you're talking about.
I understand that.
You're combining them now to one.
I'm not combining it. I'm telling you, and I'll give you the notes from the prior meetings with prior chairman and other people sitting at the table there, saying that we don't need bank statements from people who are not required to submit PQs. Just a chart with how much they're putting in and where it's coming from.
But the situation
is the only one that counts.
The situation he described is 30 people putting in the same amount of money. So under your theory, we would not take bank statements from anybody.
You take bank statements from everybody who's putting in owns 10%.
He's not saying that. He's saying 30 people where everybody was equal. And that's what we were responding to.
That's just one example.
I know, but that's what we were responding to.
So what about my question? Like I said, your opinion is the only one that matters. I just need to know what it is.
If you've got 30 people under his scenario that are
in
equal.
my scenario, they're 1, 2% each. They're all putting in some money to get their 1, 2% each. There are a few.
Then we go down to until we have a majority ownership.
Majority ownership.
Correct. I mean, that's generally what we've been doing.
Well, that could be
I don't know what licensing is doing on the one section requiring the bank records. Once again, we're talking about two different things here.
Bank record.
For the PQs, it's kind of cut and dry, but I would turn to Adam and Amy.
So, Amy, whatever
how much do we need for the bank records?
We don't need an answer today. We just need
This
an
isn't
answer.
something I don't think you can just give an answer to. I think each scenario is different, and you have to take a look at where is the money coming from? How many bank statements are we talking about? What are the percentage these people are putting in? You may only need 2 sets of bank statements.
So you're looking at the percentage of money.
Right.
And again, as Tom said, there's a distinction between personal
Right.
questionnaires and money. So if I have a guy that had, however many, more than the 11, I'm giving you personal questionnaires on 10% or more, I might have to give you bank accounts.
But it's not even a 10% or more.
But I'm saying, I might be giving you bank accounts on the guy that has 2% interest, but is putting in 50% of the money without a personal questionnaire. Would that be correct?
I want to see the 50% of money.
Yes, absolutely. I get it. But I don't have to give you the
backing
personal
this.
question. So I'm giving you bank statements without a personal questionnaire.
If you don't need license, correct.
It would be helpful if there was some general conceptual principle that we'd be able to articulate to clients
But
on
we
this
would be
subject.
we would be here all day with the amount of different scenarios that you have.
Like even the one Mr. Bernstein brought up. It's impossible to make a general rule when you have funds. We now have funds of funds investing in things, and it's to sit there and make a general rule where most people are just dealing with individuals, but there's a lot of licenses out there that are major corporate structures, and at some point we do cut it off. There's no question. But to predict until we see it is almost impossible. We have trusts that are now getting licensed. I mean, it's
Understood. And this is the last thing I'll say on it is that for example, one rule that we heard from in the past was, and this is sort of easy to apply and to tell clients, is that if you're giving $100,000 or more, whatever your percentage is, I think that was the number, $100,000 or more, the authority is going to need some bank statements from you. And if it's less than that, then you don't. That's a clear-cut rule that everybody could work with.
But if the venture's $5 million, I mean, it depends on how much the venture's. That percentage is much different depending on what the total.
And you see me ask questions at some of these things at the board meeting. When I have somebody open a liquor store, the rent's $6,000 a month, and they're telling us they invested $5,000.
Different question, Amy. This is a quick one. You said, I think what you said was that from now on, and we don't get a lot of temps in New York City anymore because with all the vacant stores, nobody is doing an asset purchase deal. But you said you're going to need executed lease from now on with the application for the temp?
Yes.
Not as a condition.
When it comes in with the temporary, when you send in that application and it's got a temp with it,
right.
We need an executed lease.
That's not how it works.
Now we're going to have somebody operating without. How do we know that they have?
When you're doing it conditional.
No. How can you take a temporary retail permit to start operating in the premises if you don't have any right to the premises?
You normally have a contract of sale. You file that with the temp and permanent application. The temp gets approved, then they close on the transaction.
Then they close.
And we get the lease assignment, and then we bring it to you and we get
Before
the temp.
we issue.
Well,
It's issued.
Temporary.
That's what she's talking about. Issue.
Before we issue one.
She said, I wanted to clarify. I thought you said the filing of it.
No, issuance.
Before we issue it, we have to have an
Okay,
executed.
so not with the filing though.
Yes.
That's what I wanted to. I thought I heard you say filing.
One more question.
I just wanted to go back about the temporary. The reason we want to grab the temporary is because if we have any kind of violation, you cancel the temporary and you cancel the permanent. You said that we should let the temporary go 90 days. We run and get that temporary when it's issued or when it's approved, because you cancel our license if somebody has a push or a disciplinary or a ticket is issued while the license is
I'm not telling you when to turn the temp in. I'm just telling you when people tell me they can't afford to get a temp, that they don't understand that the temp is basically the same cost as the permanent license when you do it on a daily basis. You can turn it in anytime you want to. If that's the reason you want to turn it in because you're afraid we're going to shut you down, that concerns me, to be honest with you, that you would say that. But I'm just telling you when I get responses, particularly upstate, that my client can't afford a temp. Well, if they can afford the regular license, they can afford a temp. Because the temp allows you to operate, and it's on a daily basis. It's actually cheaper than the normal license.
And when will you permit us, you know how we said that any pictures, you want pictures no matter what the location looks like, and then you ask for ready to open pictures when we get the license. And sometimes in construction, the amendments happen. Can we amend a diagram if prior to picking up the permanent license, if the construction guy says, let's move the bar a little bit over here, do you permit us in the middle of that to do those amendments and not wait till the license is issued and then do amendments? Because it looks like more work for you.
I think minor changes, as long as they're not materially changing what the application says. I mean, if you are constructing a one-floor establishment and then you're suddenly dividing it up into 3 different establishments and putting 3 more bars in, and then whatever the case is, if we're not materially changing the facts of the application, then I would say yes.
But if you're moving the bar or making it larger, we need an amended diagram for that.
And then the last thing, landlords don't give us their home address. No matter, they won't give it to us. So we're giving you their business address, which is where they want their correspondence to go. Sometimes it's an attorney's office.
9 times out of 10, we don't get any address. It's blank.
Oh, okay.
So provide us with something.
Okay.
Yes.
Did you say that there's a difference with financial disclosures between LLCs and corporations, as how far as you're treating them, or requiring bank statements or personal questionnaires being
Yes,
applied?
Okay.
No. Yeah, I'm saying.
Same information, but I mean, as far as the breakdown, maybe self. You may consider that.
Okay, Maureen's going to talk a little bit about permits.
Okay, I just want to touch base a little bit on the special event permits that you will go online and you will apply for. Any type of catering permit, or your wine and cider permit. Can you speak up? Sure, I guess I'll stand. So these are any type of permits where you're having a function or an event at an unlicensed premises. We ask that you apply at least 15 days in advance. In the past, we have always tried to accommodate everyone who has applied for a permit. It's no longer possible with the volume of permits that we have coming in and the amount of time it takes to process them. We do not want people saying no to events, but it's getting more difficult to process, so we have been disapproving more. So we really need you to apply at least 15 days in advance. Some excuses that we hear, well, we can't get the landlord to sign, send the application in anyway. As long as it's here, we can review it, we can always send a deficiency. Of course, we like complete applications, but for the one-off, we're not going to disapprove it just for being incomplete if it was submitted on time. So when you're applying on the website, you're going to, if it's a licensee, you're going to apply as the licensee's name. You have two choices. You can apply as an individual or an organization. So if you're applying as an organization, if you're a firehouse or if you're a licensee, it's always organization. The only exception would be a sole proprietorship. Please let us know that you are licensed. That's very important. This is information that we have to be aware of. We also, when you are applying for the permit, the landlord authorization that you have to submit has to match the applicant name. So if you are applying in the name of the firehouse and it's a benefit for the firehouse, that applicant name on the landlord has to match. A lot of times we got to try to figure out who the applicant is. Maybe the fire chief applied for the application, and we got to try to figure out who actually is the applicant. The permit should match whoever's writing the check to purchase the alcohol. Anybody benefiting from the permit, that has to be in the applicant's name too. We have occasions, especially in New York City, where we issue permits. There's multiple licenses at a location. Someone is applying for a permit. Please just tell us what floor, what suite, unlicensed area. Yes, we realize there's a license at this location. Just it takes a lot of research. Our examiners, they're brand new most times, and it takes a lot more to try to train them and look at. We might have to go back to an establishment questionnaire to figure out if the location's licensed or not. We do not issue permits to locations that are licensed or have a pending license. On occasion, we've done soft openings occasionally. Maybe we have a premises, a location that has, maybe they serve one type of food and the bride says, I really want my venue, I want my location here, can I bring in my own caterer? We've made exceptions. We do ask that the licensee de-license for the day, but please ask in advance. You can send an email to permits anytime. We'll get back to you.
And that's going to happen, and has happened, and will continue to happen very, very rarely.
Yeah. So the purpose of the permits is for a function, occasion, or an event. Not so we can pop up for 30 days over at a theater or a park or something like that. It has to be for limited functions, occasions, or events. They're limited to 4 for temporary beer, wine, and cider permits. Exceptions would be your non-for-profit organizations, as long as they're holding the event to benefit the non-for-profit organization. We do reserve the right to limit the location at any time if at any time we feel that it would be better served by a license. Caterers permits, there's no limit. However, we're kind of seeing now a trend where one caterer will go in and he'll apply at one location Friday, Saturday, Sunday. So we're looking more at those. We do reserve the right. We cut up those locations. If they're doing it every Friday, Saturday, Sunday, they need a license for that location. A caterer's permit. We're getting a lot of caterer's permits for raw foods, warehouses. So these caterer's permits, when you're operating under a caterer permit, you must be hired by an entity to serve both food and alcohol. And it's supposed to be a private indoor event. If you are outside, it must be tented. And if you could do pre-ticketed, pre-sold tickets. but I can't walk into that venue and purchase a ticket and allow myself in.
Now, and I just to that point, I can't tell you how major a problem that is in the New York City area. We get hundreds of caterers permits for what amount to block parties, that there's no food, and they just want the full bar, and it's in an empty auto yard that has nothing in it, and we end up with a forged landlord authorization form. There are representatives, and I'm not going to name anybody, who are submitting these things. That has to stop. It's causing enormous amount of time for Maureen and her people to have to review this, to chase down the landlord. We literally had a landlord on the phone who had no idea that they were going to have a party for 3,000 people in his auto yard, that wanted a caterer's permit and did not understand that they weren't allowed to have a caterer's permit because the law, not us, says what the qualifications and the obligations are under a caterer's permit. So if you're doing those types of parties, I would suggest you stop, because on their face they're being rejected.
For those raw spaces, we will ask for a temporary place of assembly permit because we don't know. It looks like a big warehouse. It has to be safe for occupancy. Your security has to be real good, especially if you have an event for 3,000 people. We may ask for a contract. We may ask for how are you going to serve food. You're a restaurant that seats 30 people, but you're applying for a permit for this big event for 3,000 people. How are you going to serve 3,000 people? The purpose of the caterer's permit, the food must be incidental to the service of alcohol, so that has to be the main focus. The alcohol is not supposed to be the main focus. That's it for permits. I do want to touch base a little bit on brand labels. I don't know how many of you are involved in submitting brand label applications.
Well, let me see if anybody is. Is anybody here a manufacturer?
Interested?
You are?
We got some hands up.
Okay, go ahead.
Okay, I'll just go over it really quickly. So we see one of the biggest things we see with the manufacturers is that they are having the out-of-state. This only applies to products that are coming into New York State from out of state. They're having the importer, manufacturer, wholesale, whoever, fill out the application in California. This is your application as a wholesaler and manufacturer in New York State. You are submitting the application. You are representing the product, therefore you must fill out that application. I don't know how many times a day we take phone calls. Well, I submitted the application. Well, who are you? I'm an importer in California. You should not be submitting the application. New York State supplier, they sign the application. They're certifying that all the information is correct. It's going under their name, so if we have to pull a product or something, it's under their license. With the products that we are registering, the wholesaler, if they are not the brand owner, they have to submit an appointment letter stating, I am the brand owner, I am appointing ABC Wholesaler as my New York exclusive brand agent. Each brand needs to be put on that letter. It cannot cover the whole line. We find out, and the reason why is we find out later down the road, maybe I want this wholesaler to handle my whiskeys and this wholesaler to handle my vodkas. So it gets split around, so we can't have just general appointment letters for that. It must include the fanciful name and year of the product. And then something new went into legislation earlier in the year. If you have a COLA, you submit your application, a COLA, you submit it certified. If you don't hear from us within 7 days, it's approved. And that's only with COLA applications. Sent certified, correct. That doesn't apply for wine products, anything under 6%. A lot of New York State manufacturers of beer, they don't require a COLA. If it's brewed, sold, and bottled exclusively in New York State, we don't ask for a COLA. So that wouldn't fall into 7 days either. It's just if it has a COLA and it's sent certified.
So under that scenario, it probably behooves you to get the COLA in order to be able to certify the brand label mailing and then get automatic approval in 7 days, because we're not doing them in 7 days right now.
I think that's all that I have on permits. Yes.
For those brand labels without colas, are you giving out a processing time?
We're over 30 days right now. We're trying. It's going to get down. We're adding more people to review applications. We're getting through them quicker. But it's when you have two sets of applications coming in, the certified and the non-certified, you got to pay attention to both of them. So unfortunately, it has delayed our non-certified submissions.
And we're in the process of automating the whole thing.
Yes.
So right now, I think all renewals are.
Liquor renewals just went online, which we've heard really good things about. We're slowly, the next transition will be your beer, your cider and your wine products. Those are going online at the end of February. And then we will hopefully, you'll be applying online for them. And it's a really quick and seamless process. A lot of people like the renewals. You just go in, yep, renew, and pay. And then you have your approval immediately, rather than waiting for your renewal and getting all your brands together, mailing them in. Oh, if the check's not right, it goes back to the wholesaler. So it's going to save a lot of time, processing time, and review time on our end.
And once the new applications go automated, that obviously will be much quicker as well. And then everybody is under the 7-day statute. So if we don't get them done in 7 days, it's automatically. So within 6 months or less, the brand labels will all be done within 7 days or less.
And we will get there.
And that is obviously contributing to the other problems we're having, but as far as moving over to this system, but we will get there.
And just on that note, I want to make sure everyone's aware of the back office project that we're going through to automate our system. We're doing a complete overhaul of our processes throughout council, secretaries, licensing. Everyone should be aware that we aren't going to be fully automated as far as our processes. We are going to be accepting and processing applications online. Payments are going to be done online. The days of paper applications are coming to an end. And we're looking at this to be done in the next year to 18 months. I want to make sure everyone's aware of that because it's going to change, obviously, how you process your applications and the interactions you have with your clients, but everything's going to be done electronically. Hopefully the check issues, the payment issues, the applications, if things aren't completed online, they're going to be rejected from the system. Also, I know historically our leniency on timing of rejecting certain applications and our disapprovals on failure to comply and things like that, it's going to be a much different process. There's not going to be that leniency anymore because everything's built in and automated. So if you don't send in your deficiency letter on that 10th day, we have no discretion. It's automatically getting kicked out of the system for disapproval. So some of those luxuries on time that you've had in the past, you're not going to have going forward. And that's just because everything's automated, everything's going to be digital and on time. Yes?
I was informed that you guys are no longer going to issue the temporary permits.
I can't hear you. Can you speak up?
I was informed that the temporary permits will no longer be issued here at this office.
Yeah, so everyone knows the temporary retail permits are emailed. And
right, but there have been circumstances where you come here, pick them up, and get issued the same day. So you will no longer.
So I guess I'm trying to understand why would you need to come here and make a trip to the office if we can email it.
I'm just saying that's just what I was informed. I just want to make sure that's correct.
Yes.
Okay. And then the other thing, has it ever been a possibility to put that under the online system to expect things like the after the 90 days have been issued, that we could just do that online?
No.
Not now, but it will all be online in, like you said, this thing should be up and running in early, I guess, spring of 2021. Permanently, we should be done with that. I'm correct in saying that, right?
Yeah.
And at that point, everything we do will be on that system.
Yes.
I just
the back office, right?
follow up with your question on temporary permits. I know that there have been circumstances where I've had to come in person to submit conditional approval requirements for temporary.
Can you rate? Because we have a mic right here, and they're trying to hear you in Buffalo and Albany. So can you just speak up?
Oh, okay. With regard to temporary permits, I'm talking about the ST permits and not the daily event permits. There have been circumstances where if there's a closing that we're trying to time up with a liquor license transfer, where we've had to come here in person to submit conditional approval requirements for temporary permits to make sure that they get issued concurrent with closing. Otherwise, there's sort of a lag time between closing and when the new entity comes in and takes over. So is that something we would still be able to do? We're talking about usually major venues, event centers and things like that.
So the question was, when she has applied for a temp and she's trying to time it with the closing, is it all right to come here and, with the fulfillment of conditions and try to pick up the temp? I go back to what Adam said. Everybody has one of these. When he says that we're going to email it to you, he's emailing it almost instantaneously once the conditions are filled. So I don't know why you would need to do that. I mean, I get you want to come here and fill out and fulfill the conditions as quickly as possible, but the email's going out right after that.
Just that, when we get them by email, we don't always get them the same day. There can be a few days lag time. The same when we're sending them by Federal Express to Albany. We can't be sure what day we're actually going to get the response. Usually, if I send...
Well, are you not sending them out the day the conditions are fulfilled?
Oh, usually within 24 hours.
It might also involve a surrender of a license.
Yeah, a physical document, that's true. Yeah. You have to bring in the original license from the person who was running the...
I think we'll have to take a look at that policy as it stands right now, because I do understand there's some circumstances and timing which people need to be open and want to be open. I think from our standpoint, it's especially down here with that kind of transaction, it's volume. So we'll have to consider what the impact on our folks is and how we can be most beneficial to everybody in the industry. So that is certainly a policy that we'll take a look at, and we will make sure that it's made publicly available on any decision that's made on that.
Are you allowing it in Albany still? Pick up in person? Or
Not generally, no. Yes.
Just for order of transparency, these time frames of delay, are they posted anywhere?
Yeah, I mean, so out of the licensing info mailbox, because most people's requests tended to go there, we had an auto reply going out to people advising the time. We will make sure that those time frames are posted publicly. But I also encourage you all to check in with us once in a while to see what our processing times are. That's going to change, and our full expectation is that those processing times are going to go down. As they've gone up in the last few months, we do expect those times to be going down. So we will make that information available to people and encourage you all to check in once in a while to find out what our processing times are, or better, what application dates we're reviewing. I think that may be just as beneficial to everybody to know where we're at as far as applications submitted.
And we check it. I can tell you I'm checking it every day, as is pretty much everybody else that is involved in licensing at this table.
Yes,
Mr. Roberts, all of our emails. How come we don't get regular advisories from the SLA if we're going towards automation? That meaning in two senses. One, with licensing policies and changes. And two, when I've requested on the responses to disciplinary that I be sent a date when the hearing is on the calendar. If I don't look at the calendar every month, twice a month, I might miss a meeting. Why aren't we getting notified? I put it specifically that I want...
I can address that part. For the disciplinary, for full board, we are not notifying on disciplinary matters. There's just too many of them, right? And some people want to be notified, some people don't. The calendar goes up a week before the full board meeting, and you can check it then. For licensing, the applicant, the representative, and then the opposition get notified. But we have too many disciplinary. My staff is too small to be. Now, with the new system, that's going to change. Because with the new system, you're going to have your email addresses into the system, and the minute we put something on the calendar, you're going to get an email.
As far as the general advisories that you're talking about, we try to put up as much information on the website as we can, as regularly as we can, particularly when we change any major policy or licensing issue. But I don't have everybody's email. I don't know what gave you that idea. In fact, there's faces in this room I've never seen before. And there's faces in that room I've never seen before. So, there's people here that do this only do this type of work, and there's people here that do this type of work and several other kinds of work. So, I don't know what. We don't have somebody that can sit here and type up a letter every week and say, hey, here's what's new with the Liquor Authority. That's just not going to happen. But check our website regularly. We do put any information there. I encourage you to follow us on Instagram, follow us on Twitter. We have all of that. We do have somebody that works that on a daily basis. So,
Mr. McGrath?
What's Twitter?
On the self-serve, what's the time frame today on the self-serve?
30 days quicker than our normal time. So we're in the first week of June right now.
We are mid-June.
We're working mid-June applications for self-service.
I have another question. On this,
So just before you ask that, for the people in Albany and Buffalo, the question was, what's the timing on the self-cert right now? And Amy's answer was mid-June.
dealing as we did before about personal questionnaires and financial statements. Today we have a lot of situations where we have a proprietor who's going to run the operation, but to get financing goes, or somebody goes to a fund of some sort, who has nothing to do with other than they take a part of the profit. So they sign a document that says they don't have anything to do with the operation. And they have hundreds, maybe even thousands of people who are involved in this corporation or a hedge fund. Now, what's the policy? Is it a policy that we're going to come to you before, explain the situation to you, or is there going to be a rule that the hedge funds are exempt, or that the major corporations that do in fact take a part of the action but have nothing to do with the operation?
So I mean, so they are making an investment into the company, not loaning somebody the money.
Sorry,
They are making an investment into the company.
Yes.
As far as money.
They're not lending; they're actually getting an equity position. Now, there are two situations. One situation, strictly an equity position; they rise and fall on the success. The other situation is some of the hedge funds take a position, they sign a document that if the proprietor violates this provision and that provision, they're going to move in and try to take control. So I think, is it a position at this time that we should come to you, we have that type of situation?
Yes, I think it's fair to say that. I mean, because as we are dealing with more applications, obviously the chairman alluded to the corporate structures that we're dealing with today in some of these applications are extremely, extremely challenging, both for you guys to figure out and then for us to figure out, because there are so many different holding corporations, shell companies for tax purposes, irrevocable trusts. So I think you have a complicated corporate structure where the money flows funny and there's certain agreements that are made that you should certainly come to us and talk about it before we get the approval process going. Just so that way we are all clear on what's happening and it doesn't delay it down the road for us to try to figure out the corporate structure. Yes?
Sort of to clarify though, like a very, very common scenario that I think we'd love some guidance on is, you have 2 or 3 principals that they collectively own, 80% of the company, but a good chunk of the money is coming from a whole lot of people that only have 1 or 2%, and we have it in generally not submitted bank statements for every one of those 20 people. We have an account number, a spreadsheet of disqualifications, and that's what we have submitted, because none of them are people that would have filled out personal questionnaires, and so we've never been having them just submitting a bunch of bank statements if it's not tied to people with a personal questionnaire. I think that's what Rob was talking about. So if that's a change, I think we really do need to know what the policy is, and that's a scenario that happens all the time. I can't be emailing every single time saying,
Sure.
we have 15 people here, 5 principals that are running the show, they're managing, and then a whole lot of people that put in $1,000 that they all suddenly need to now, what are we getting?
Yeah, so I mean, I think from our standpoint at this point, we'll have to take it back and discuss internally and come up with some guidelines for people so at least they have a general understanding of what we expect. Again, we understand that there's going to be situations that fall into that gray area, but we will put out a policy in the near future as far as expectations on what we are expecting to see generally.
Adam, related to that is, and this is just happening lately, is if we have, say, 50 to 100 to 150 investors that we are not identifying because none of them have 10% or more, we've been asked now to get a letter from one of the principals that says that based upon that person's information, none of those people have any statutory disqualification. Very difficult. If you have a handful of people, 20, 30, 40, that's one thing. If you've got a fund that's part owner that's got 1,000 people, there's no way that they can provide that information. So I'm not looking for an answer for that, but
be aware.
I just want to let you know that's been an issue.
And what's you're saying they own a small percentage in that?
We're going to require a statement that none of them are statutorily disqualified
In those situations in the past, we've given you a PQ from whoever's running the investment fund, just so if that investment fund owns 10% or more. But I was told we don't need Obviously, if there's dozens or hundreds of people in that investment fund, you never needed all the information of those people. That's just what I was told.
No, and I think that probably, we'll talk about it, but I think that's going to remain, that is still the same. I mean, as long as there's somebody that is running the fund and the people that are investing in the fund have no input into what that fund invests in, they're all passive, it makes no sense that we would ask for any information.
Maybe a question?
I'm going to make a suggestion, because nobody really has suggested or responded to how we can help the liquor authority. It's amazing to me that the people don't understand, attorneys and the public, the thousands of applications you people get. It's unbelievable. Nobody understands the number, although the chairman did mention it one time before, 1,000 a week to 1,400 a week, probably even more. It's just absolutely incredible. And only the older guys know all the people that are leaving the authority because of the pension and everything. You're losing a tremendous number of people, and this is why we got into the situation, which we've had previously in the 60s and the 70s and the 80s. I think only Mr. Dottie remembers that. Nobody else has been around. Let me ask you this about a suggestion. What about pro bono work? You have Buffalo with tremendous attorneys. You have Albany with tremendous attorneys. Needless to say, you have Manhattan with tremendous attorneys. You work advisories with the attorneys. You work on CNCs, the legal department with attorneys. What is wrong with looking to the public, looking to those attorneys, people who have experience to come in? We're required to do large firms pro bono work. Have them come in with pro bono work to help you in this monumental problem that you have. You just don't have the staff. I'm just throwing it out as a lot of times you have to look at a problem outside of the box. Maybe this is something that, because I think that you're going to find and be quite amazed that the public would want to do that. Because we have licenses now, people are waiting 6 months. They can't. I have one client that's paying $20,000 a month on rent. They can't survive. They can't. It's a crisis stage. So I'm just saying, maybe we look out of the box, and that's a possibility. Now, how do we address it with the governor and everything? The other thing is, the filing fees that you have are $1,800 a year for filing fees. Go back to the 1800s. Why did you have a corporate change for $128? Open it up to $1,000. Why do you have liquidators permits for $36? Open it up to like $500, $600.
You represent clients?
So just on that aspect, I'm not going to. The fees that we charge, we have absolutely no control over. They're statutory.
Right.
So I mean, but you understand as well as I do how hard it is to change a statute. I've tried to do it.
But I'm just saying, it's if you can go to the governor and you can go to the budget people, and you guys are under tremendous scrutiny as far as the budget, it's absolutely amazing. You're the second most income-producing agency in the state, and you're treated like crap. It's unbelievable. They don't bring enough people. They don't give you provide.
He said that, I didn't.
And so I'm just saying that sometimes you have to think out of the box, that possibly on negotiation or coming up to the governor's office, if you ask him for something, and then you give them, you know how crazy they are about increasing fees and everything. And, we handle clients, liquor stores, or, liquidators permit. Come on, it's hundreds of thousands of dollars the liquor store makes on income on increasing the liquidator's permit from $36 to like $500 and something. Everybody goes, ooh, you're crazy. What are you talking about? It's something that's rational. So I'm just saying, think about it.
No, and we are thinking about everything. I can tell you that we deal with this on a daily basis, not just within our own agency, but I have had meetings outside the agency on a regular basis and will continue to do that. No one is, everybody is on board trying to fix this. There's no question about that. We're spending every day to do it. We're spending all of our time doing it.
This might be an element.
And we're getting as much support as we can from the governor's administration. No one has said no to us. They just want to know what the situation is, and we're telling them. We're being honest with you. We're being honest with them.
I think what he's saying is if we knew as an industry that increased fees would result in increased personnel rather than just increased fees, but increased people for you, I think you would find a reasonable response from the industry. But if it's just increased fees to go into the state's general fund, then
Right,
it's going to walk
exactly.
on.
And I don't have, like I said, I don't have any control over that, so I couldn't even answer that question. Well, Mr. Lynn, I understand what you're saying, but we are thinking about every possible aspect
And
of
the
this.
last thing that I just suggested, because I went through it in the 60s and 70s, I think Tom did too.
I'm not that old.
Talking about the 1860s. We had a crisis in the liquor authority. 8 months, 9 months for processing applications.
Well, if it ever gets to that, I can guarantee you won't be yelling at me.
But what they did was, as amazing they seem, they rubber stamped approvals at that time. And the only thing that I'm saying is, you have an application like Shake Shack or something, which goes through the entire process, and Amy has to go through the application. Isn't there a way to somewhat simplify? I'm not saying rubber stamp it, but there are entities within the industry that you could possibly do this because, it'll save a tremendous
You would
amount
like
of
to.
time.
You would
And
like
saying,
to.
I know you're giving a
No, you would like to think that, and I can tell you that's not the case, and that is unfortunate, because as I pointed out, we have a self-certified application system for lawyers that should really mean that we pick up the application, we look at the checklist, and we move it on. Upwards of 80 to 90% of them, we are unable to do that because they're not done right.
Because 10 things.
Well, Shake Shack has just as many issues, and you're using them as an example, not me, as everybody else.
And you have your list, and I'm saying, okay, out of the 40 things you have to do, Shake Shack or Attorney Sir doesn't include 10 of them, and therefore you can't do it. And what I'm saying is, minimize those. Those aren't priority matters. Those aren't that important. If it does come up, I'm going to just say what they did in the 60s. They said, something will have enforcement. Enforcement will take care of it down the road. I'm just saying there's a crisis now at the liquor authority because the public is being hurt. The state liquor authority.
We're fully aware of that, but not doing the work that we're charged with doing doesn't really solve that problem down the road.
The state liquor authority has an obligation to the public, and I think that obligation is being negated right now. And therefore, you have to think out of the box and make priorities as to what's important. You're not going to have Shake Shack bring in organized crime to operate restaurants. So I'm saying that there is a way. I'm just saying to think about it. This is an option. This is thinking out of the box. This is thinking of a total program that you can do. That's all I'm saying.
Okay, we have other people that want to ask questions, though.
Yeah, just a couple of points. On the removal application and the regular license application approvals, there are different time frames. I'm starting to get some on the removals that say 6 months, other removals I get in that say 90 days. Is there any reason why it can't just all be 6 months so we don't have to come in and ask for extensions? I mean, actually removing a business and building out at the new location is really not much different than building out at a new location.
To people's point, yeah, right. So our goal on the removal applications and putting those along quicker is so that people aren't paying rent in two places. So we.
No, I'm talking about I get a conditional letter of approval. On a removal application, it was always 90 days to pick up the license. Then I started getting some in that said, I don't know why, 6 months. Most of them still say 90 days. All I'm suggesting is, and sometimes they just don't get it done, and we're emailing for extensions and whatnot.
Yeah,
Can we just have a blanket 6 months on the removal and the regular?
I don't know if that's.
I mean, everyone wants to pick it up as quickly as possible, obviously, but
If that's not statutory, which I don't know off the top of my head if it is or not. If it's not, you can have 6 months. I don't have an issue with that.
Yeah.
So they'll go check that when you get back.
Well, conditional approval is on statutory. In fact,
No, he's talking about the removal. That's not statutory.
But it's the conditional approval of the removal.
I'm saying that on the conditional it says you've got 90 days to pick up.
All right, it'll be 6
You've
months.
addressed that already in the delegation and the advisory without any change.
Okay.
So, two, and I just want to bring up the issue again. It was mentioned earlier. I, for years, have been advising clients not to apply for temporary retail permits. Not because of the cost of the permit or anything like that. Simply because of what I've seen and the number of people, applicants have come to me that I haven't even represented, that have been operating under 90-day permits. There's a sale to minors, something happens. Obviously, it's not right, but, you know, a sting operation happens at the tavern, at the restaurant, at the liquor store. The application's immediate, the temp is immediately annulled, and the license application is disapproved. Under those circumstances, I mean, I constantly advise clients, do not apply for a temporary. Is that still the policy with regard to this, or is there more discretion? I mean, is a first-time sale to minor going to get your temp fake annulled and the application disapproved?
So you're talking about the degree of disciplinary action that we take that we would pull from an applicant.
I'm sorry, I didn't hear that.
So you're talking about the degree of disciplinary action that we would take to pull the ST. You're asking what our limits are, or what our threshold is for doing
Well, I
that?
mean, is that still the policy?
Yes. I mean, disciplinary actions against applicants running on temporary retail permits, I mean, we would definitely consider pulling those.
Well, what I've seen is that they are pulled, period.
But then you reconsider it.
I know, so, but now but it doesn't necessarily take 2 or 3 weeks to reconsider and get back to the board. Okay, so that's what I'm saying. Now
We can look at making that more lenient while we're in this situation. I can't express enough. You should be applying for temps.
I would love to apply for temps. Just about liquor stores are a little different.
I know, but it goes
story
back.
beyond
It goes back
COD.
to what was asked before. Is if your client is that at risk of violating, maybe you should sit down and explain it.
No, and you can explain, and that's not necessarily. Look, if they want to come in and sting you, there's a good chance, and it's not right. And believe me, you counsel clients. You've got a CID, et cetera, et cetera. But, you know, there are lapses, sting operation, minor is sold, boom, it's annulled. Now, the problem is that they've purchased the business. There's been a closing.
No, I understand the issue. We'll take a look at it. We'll
that's-
take a look at it, because I do recommend the temps.
Okay, lastly, with regard to some concern, and I take the sub-certification process very seriously. I'm out there, I walk the neighborhood, I do all that. It concerns me a little because of the type of deficiencies letters sometimes that I get. And I don't know whether they're reviewed or whether there's some discretion here. And I'll just give one simple example. The other month I got one, and it simply said one deficiency on it, and it said that I had 2 principals, 50 shares issued to one, and 50 shares of a 200 no par value company issued to the other. The deficiency letter questioned, where are the other 100 shares? So, obviously, I wrote back and I explained how a corporate structure works and how there's only 50 shares or a total of 100 shares issued out of the corporation. The corporation is retaining the other 100 shares. They're unissued. All right, and that resolved the problem. But now,
No, that's not. You'll get a deficiency, but that's not going to change. You'll be fine. That's a misunderstanding on our end. You'll be fine.
Okay, so someone is reviewing it.
Yes.
It's out of deficiency, and I'm being told you're off.
No, the issues that we're having are when someone says that, as I pointed out, and I'm going to use the 200-foot thing again. No, not within. Check off the box. No, not within 200 feet. That's a blatant lie.
I don't understand how that could even happen.
It happens a lot.
No, and I get that, but I'm just saying.
And it's not. It would be. When I see it, who it's happening to is even more shocking, because it means that this person is just—they're not doing it at all, and they're signing the certification and handing it in.
I get that. That's
so yes, to your point, there is a review process on those self-certified applications. We don't just automatically disapprove based on that deficiency. We certainly look at the reason why the deficiency letter went out, and there is some common sense reasons. If our question was not clear about what we were asking for, then we will absolutely take responsibility for that question, or if it's an error on our part.
And we have a lot of new people, as Amy pointed out, and we're going to get a lot more new people. I mean, I think I was told today that the majority of our examiners have not been here even 2 years. That's throughout the state. And so we are going to make mistakes. As we try to get this number down, which I have every belief that we will, we are going to make mistakes because these people are going to learn, and while they get experience, and they have to learn on the job.
There's a question from Albany.
Yes.
Hi, I have 2 quick questions. One for temporary retail permits. I understand the new policy, you have to submit a lease. Can you submit a letter of intent
As long as you have a right to the property, you need to submit something that gives you the right to the property when we issue the temp.
And a letter of intent would do that, the SLA?
No.
Oh, no? Okay, so it's got to be a fully executed lease?
When we issue the temp, you can walk in, as one of the conditions, we're going to require an executed right to the property.
Okay, and then the second question is just with regard to the timeline. I'm understanding 24 to 26 weeks processing time from the time that it's mailed, but is that until, let's say a deficiency letter is issued? Is that 24, 26 weeks from mailing to deficiency letter?
It's from mailing to time of decision is our approximate. Deficiency letters go out at various points of the process, so we can't really peg it down a time frame for that. But it's 24 to 26 weeks from the time of mailing to time of decision.
And the point of this is to eliminate deficiency letters. So
No, I understand that.
I know that's not going to happen. But.
Yeah, so in other words, if you submit a perfect application, no deficiencies, that's 26 weeks to conditional letter?
Give or take, yes.
Okay, all right, thank you.
Unless it's self-certified, which knocks off about 30 days currently.
Got it, thank you.
And going on that, if we have a closing that's pending, the client is buying the entire restaurant and everything, they have to get the temporary liquor license. Can we have the closing based on the contract that says the closing will occur upon receipt of the conditional, of the temporary license?
Yes. Yeah.
Okay.
No, not on the receipt. Not conditional license. On the conditional approval.
On the conditional approval of the temporary license?
Yes.
Okay. A second question is, if a client has a farm cidery license, they're producing the hard cider, they switch over to a regular winery license, not a farm winery license, can they still call the alcoholic fermented beverage apple cider or hard cider, or do they have to call it apple wine now?
Some of these specific questions that I don't want to get into at this point. If you guys have questions about certain applications going from one to the other, or the process behind that, shoot an info to licensing info mailbox.
Well, that one you asked TTB.
For the labeling issue, because it comes down to how we change the labels.
Right, and wine, we don't brand register wine if it has a cola. It's already considered approved.
It's still under the alcoholic requirement for cola.
All right, well, that's a specific question you need to ask.
Send an email to the craft beverage email address.
Okay.
Yes.
When can you use the items already on file form?
That's when you're filing a class change.
Class
And that's
change
not
only?
for the items listed. That's for personal questionnaires, diagrams. Those sections of the application you still have to provide.
And the other is with the endorsement application versus the corporate change application. I noticed that you've got statements, do not use this application if you're doing this, this, or this. One of the items that I don't see on there is if you're changing from a corporation to an LLC, you're requiring a brand new application, and perhaps you can add that to that application or change that whole thing.
Okay.
Yes.
Along the certificate of occupancy, I've noticed that of late, they've come back and saying that they're not being accepted because of the eating and drinking establishment. Even though they have the right zoning group and number of occupancies of people allowed at that premise.
So generally, you need to be in use group 6 for our purposes.
Right.
We would prefer that it says eating and drinking establishments, but I've advised staff that if you are in use group 6 on your C of O, that is acceptable for our purposes.
So recently, the Department of Building are no longer issuing letter of no objections if we have the right group number and just letting you know that.
Do you know how recent that was? We had a meeting with DOB last month, 6 weeks ago, to discuss some of this stuff, because obviously a lot of concerns that people have about C of Os are concerns that we have, because we understand that there are certain things at DOB that we can't control, but that we rely on and you folks rely on. We had a meeting with them, and my understanding was that the LNO was to be issued for SLA purposes when the original C of O didn't have a use group associated with it. So if that is something that you guys are getting different information on, which it sounds like it may be the case, I will reach out to our contact at DOB to get clarification on that. And if that's something that we need to change, then we will consider doing so, or ask them why that policy was in effect. Because, as I mentioned, as of our last meeting recently, the LNO had been issued for those kinds of CFOs, because obviously they come up frequently for what we deal with.
they have an old, they have a directive on that. And though I never walk into that building, but I deal with architects who do it a lot. And they were told that if it's a valid C of O, we're not issuing an LNO. And valid C of O could be a pre-1960 C of O, which was before use groups were invented.
Right.
And if it says store, and it's zoned properly, they say they're not issuing an LNO. They have something called a letter of verification, which I've never seen, but that they said they might issue in a situation like that if you need to explain it. But C of O is a valid C of O, even though there's no use group.
So that is something we will continue to work with DOB on, Mr. McGrath.
This comment is one of the agency. I think that I don't speak for this group, but I believe what I'm going to say is true everywhere. To send our applications to Philadelphia is a PR situation waiting to happen. Some critical journalist.
Mr. McGrath, if I could stop you there. This was not done in a vacuum. I was born at night, but not last night. All I can tell you is that it's not our contract, that we didn't have a lot to do with it, and whatever risks or problems are associated with that have been articulated. And that's the end of that.
Yeah, I was just going to suggest something if you let me finish.
Well, there's nothing really to suggest because it's out of our control.
No, I know it's out of your control, and I know you had nothing to do with this contract. But I'm suggesting that we as an industry support contacting the second floor and pointing out how ridiculous it is for an authority to be sending something to Philadelphia.
As I told you, it's the comptroller's office contract, so that the second floor is not even involved in it. But you're welcome to contact anyone you want. I'm not gonna tell you not to contact somebody.
You stated earlier that you don't want us contacting licensing, you don't want us sending emails, and then just contact anyone about processing time. Perhaps put processing time for different applications on the website so that it's clear and that we don't have to contact.
Well, just before you answer that, he's not telling you not to contact us. What he's telling you is we have a number of different outlets that you can contact us at, depending on what you're asking. We have a craft beverage email, which anything revolving around craft beverage manufacturing should go to that email. If you have a disciplinary email, we have
it's opening legal information.
Legal information that they should be going there. So, but I understand what you're saying, but what's happening is everything is going right into the licensing email, and it doesn't help us if that happens.
But for something like this, where it's probably a pretty common question to get from clients as well as attorneys what the current processing times were, if you didn't have to contact anybody, so we're not going up any email box, and it was just out there online, you think that would be helpful for
I think it is online right now. We try to update it.
We'll take that into consideration.
online? And my other question is just with certificates of the same name. I've been noticing that you're not accepting the applicant to just drop the or the or LLC from the name, and that even when it's just something that simple, where it's like the bar and they're going by bar, you're requiring your certificate of the same name now. Is this something that's typical?
No, is that something that you're seeing down here in the city?
Yes.
Okay. That's not.
And I've reached out on a couple of occasions and said, is this now required? Because obviously it's contrary to the statutory requirements, since it's clearly discernible from the name and you're only dropping the or the corporation entity, but have not received any response and we've still been requiring.
Hope that's something we'll address with our staff universally. Open.
On the 500-foot statements, I wish it were true that in New York City, every restaurant filling up a vacant restaurant, there was something unique, to put into the 500-foot statement. But after 30 years of doing these applications in New York, I can assure you that's not the case. And I don't see anything wrong, therefore, with doing a standard 500-foot statement that pretty much states it's a new business, it has community board approval. It meets the what minimal statutory guidance that the 500-foot law provides. You can't just make up stuff, when it doesn't exist. I mean, there are 200 Italian restaurants in Manhattan. There's 500.
No one's asking you to make anything up. I think what the point of it is we don't want to see the same letter and just change the name at the
Why
top.
not? If it's applicable,
Because
why not?
that's not the purpose of the law, and it gives us
Sure
no, it isn't. If you're supposed to make a public interest statement,
Right.
then make a public interest statement. It shouldn't be the same public interest statement for somebody on the Lower East Side as it is for somebody on the Upper West Side.
Why?
Because that's
Says
not
who?
my belief about what the law is intended to do is not that.
I think
Can
it
I,
is
can I make a, can I make a suggestion? Can I make a suggestion? The purpose of this meeting is not to argue about specific policies we have in place, because there are a lot of lawyers here who are all very good at arguing. We'll be here forever. So we're not going to do that. What we need to do is hear from you. If you have a suggestion for a policy that we should look at, which we can then take under advisement and get back to you. If there's anything like that, we can continue. But it doesn't really make sense to go over everything we've said.
I agree. That's my second point, is that, I've got to go back to, after this meeting, report to the trade association here that I represent. And I was hoping the news was good because we were seeing that the logins were becoming faster, so I assumed that also meant that the prior time frame that you were posted and gave us was getting faster. 6 months is a disaster. It's a crisis, especially with a statute that requires a 30-day review. We together with you, no blame here. We got here however we got here, but 6 months is a disastrous consequence. The state is losing millions of dollars in tax revenue. There are thousands of employees not being hired. We need to figure out an emergency response to an emergency. And we need to figure that out together, and we need to figure it out quickly. This is an emergency. 6 months is an emergency.
Okay. We will take that under advisement. Yes.
I just have to speak to the LNO. We send you an LNO, and then I get an email saying that the LNO needs to be upgraded. An LNO is an LNO. Why am I getting from, I know it's one in the New York City office. Why am I upgrading an LNO if it's from 2014? What's the difference? You ask for an LNO or a certificate of occupancy. Why aren't they? And then I give you a certificate of occupancy for the use for 6, and it doesn't work for you. So I don't know. Every day I get a different response.
So I said, everyone has been advised that use group 6s are the use group that we look for. We would prefer that it says eating and drinking establishment. As far as the other issue, I'm not sure the specific case. If there are open jobs at DOB that may require us to get a different verification from them. So without having specifics of that, I don't know if I can address that.
And I don't, unless you have a general policy question, we're going to move on because the legal office does want to talk to you a little bit. Well, that wasn't general, so is this one general?
This one's general. The operating system. The applications and the upgrades. How come? Because I don't know if you know, Explorer is very slow. So and freezes. So even when we're doing our temporary permits online, we're having issues. Can this program be amenable to Explorer and to Chrome so that we're not freezing up because you're only limiting us to Explorer to get an expeditious processing?
And that's a question I'll have to take back to the IT folks developing our system. Unfortunately, I don't have answers to that right now.
And then the last thing, Mr. Donahue, for specification, you told me that the email, that you can't email me about when the hearing is on the calendar, but you can email me for a fine. So why can't
For a
you
what?
use
I'm
that?
sorry, for a
fine. You have my email for the fine for the client, and you don't have my email to tell me when the client is
I didn't say we don't have your email.
calendar?
I did not say we didn't have your email. I said we have 100 or so disciplinary items on the calendar, and we don't have the time to send out an email in the current system. With the new system, it's going to be automated. You'll get the notice.
Okay.
But that's what I said a half hour ago.
No, but
Okay, all right, thank you.
One, two questions.
Yeah.
So I just heard that you prefer naturally a C of O that says use group 6, eating and drinking. A lot of times we come up with use group 6 offices. Will that be accepted?
If it's classified as use group 6,
Yeah.
we'll accept it.
Thank you.
I just have a question about the food requirement. So Amy, you spoke earlier about the food requirement as it relates to restaurant. And so I want to ask about the other side because we get questions from clients all the time. What's the minimum food requirement? And typically our response was not packaged. I have snacks and stuff that's too small. You need to have something more, something repeatable, like little things. Some bars will have like hand pies and little things. But it seems like that may have changed because we've had examiners ask for a few more items. And so what is the minimum for a bar, a dive bar, or a small cafe as far as it relates to the tavern requirement?
There's no set number of items that you need. You need to have various items on a menu that anybody can walk in and find something on the menu that they're going to order. Sometimes I see where it's all gated towards, everything's got meat in it or whatever. But I mean, Hot Pockets, anything microwavable is fine. Cold sandwiches, if they don't have a microwave or don't want a crock pot.
What about a cafe, a coffee shop that has like pastries and might not have sandwiches? They have a variety, an assortment of pastries, which there are all kinds these days. What would that be acceptable?
I would think that you would need more than a pastry.
You would need more than a pastry to classify.
Not one pastry, but if
No, I know, more
it's a
than
general
beer is
category, it's not, they're going to have
No, right, no, I know.
croissant,
And to
one
me,
croissant.
right, if we're classifying it under a pastry, to me, that's not substantive enough to say a tavern license is appropriate.
I mean, and we get asked this all the time. Nobody, the law is the way it is. We didn't write it, and we're not the ones we're just here to enforce it. But we don't care if anybody buys the stuff. So all you need to do, what she's saying, is have a freezer and put the stuff there and have the ability to heat it up. We don't care if it's there for 10 years. So I mean, this idea that these cafes can't figure out how to make a menu that complies with the tavern license is just remarkable to me. Because nobody comes in and says, how much did you sell? We only say, what are you selling?
Not like legitimate cafes where people have maybe.
Well, then make it. Or then add some stuff you don't want to sell.
All right. Again, we're debating.
No, get up. We're going to do the legal now.
What food should qualify? Let's not do that anymore.
So we will segue from licensing into our new general counsel, Gary Meyerhoff.
Okay.
This will be much briefer.
Much briefer. For those of you who don't know me, I started about 3 weeks ago after spending my career in the private sector, 20 years as a litigation partner at Denton's, which used to be Sonnenschein, Nath, and Rosenthal. For those of you who don't know what a Denton's is, it's the largest firm in the world that no one ever heard of. I am happy to work with all of you. Some of you I'm seeing for the first time, some of you I've met already. My phone will be available to you. I'm a litigator, so I guess I like arguing, so you can pick the topic and we can argue. If it makes you feel better, we can both pretend we're not arguing or that you're not representing your client's interests when you call me. It's fine with me. I'm learning as I go. One thing I know that I need to get involved in and to bring attention to is prosecutions and litigation and the process of prosecutions and litigation. It's one of my areas of strength administratively, as well as understanding tactics and all sorts of things like that. I've already noticed that there are inconsistencies in the way lawyers deal with each other in the process, inconsistencies across regions, inconsistencies amongst individual lawyers, prosecutors that you're dealing with at our agency. And I think that leads to, in some circumstances, expectations that are not getting met by you. You expect something because somebody else did it. I am going to bring order to that. That is my goal. I'm going to create written rules and guidelines and make everybody know where everybody stands, because I think it'll be better for you and for us. And that is a process that will continue over time. But because we have you all here today, I thought we would get started with a few points that I think we'd like to stress with you. And I'm going to ask Lisa Ogden to go over those with you. If you don't know Lisa, she is the deputy counsel, and she works out of Albany, but she's often here in New York, and she'll be working with me on these initiatives. I'm going to ask her to say some things, and then after that, we will take some comments, and again, in the context of suggestions for things to look at, not disagreements with what we're doing now or debates about that. So with that, I turn it over to Lisa.
Thank you. I want to thank you all for the opportunity to speak with you today about some of these things. As the chairman said and as council indicated, we do have a list today. It is brief. but it is important, okay? We're really asking for your cooperation on these things so that everybody, so we can run the office smoother, so everything can be just better run for everybody as a whole. The basics. I'll start with this first one. It's the notice of appearance. Just reminding everybody to please submit a complete notice of appearance. And you need to submit it with each disciplinary proceeding, even if you submitted a notice of appearance to the licensing bureau at the time you did an application. We need a new one. You can find it on the website. We do include a copy of it with the notice of pleading to the licensees. Just please remember to do that. Number 2.
Before you go on, Lisa, there was one thing I did want to say. I am conscious of the fact that some of you here are very experienced in dealing with us, and this is all going to be very familiar to you, and you're going to be bored. But you never know, you might hear something that you didn't know, and I beg your patience in any event. So,
thank you. My second reminder is to please respond to notice of pleading timely and in writing to avoid defaults. If we don't hear from you, we're going to default the matter. Okay? We're going to be moving forward with these cases. So if you have some understanding that we're going to contact you before we do that, please don't do that anymore. Do not expect that. Okay? Number 3, don't wait until the day of the hearing to submit the plea offer, especially when the SLA attorney has communicated it to you several times beforehand. All right? It's inconveniencing everything, and we're thinking about ways to improve this, but right now we're really asking for your cooperation on that.
yeah, just a word about that. Obviously, if you I guess the point on a lot of these is, and look, I've practiced law for a lot of years, and I know what I have time to do and what I don't have time to do when things slip, but when there's an expectation that there will be no repercussions for not doing what is customary and fair to opposing counsel, to a hearing officer, opposing counsel that's going to come in from Albany to be at a hearing, you tend to continue to do it until somebody kind of slaps you and it hurts your client or it hurts you. We're looking at ways to make sure that some of these things, end up with repercussions if the conduct of the attorneys who are practicing with us don't change. You'll hear about those. The purpose of this is to give you a gentle reminder of those things that me coming into this would think lawyers would do generally, because I saw that for most of my career, not amongst all, but amongst most in federal and state courts. So anyway, please continue.
Number 4, in the plea offer, please explain that the licensee is back into compliance and that any necessary license applications have been submitted to licensing, and make sure that they have been submitted to licensing. Right now we're considering what to do about that formally, but please make sure that you and your clients are complying with that, and if they don't, they're at the risk of getting disciplined again. Number 5, we understand that there are some inconsistencies about the way that you deliver your pleas to our offices. We are working on procedures, a uniform procedure for that as well, so you'll be hearing more about that on this earlier date.
Yes, and litigators, people who are representing clients, you should routinely check our website for alerts on new processes that we've instituted. That will be one that we will absolutely have an advisory on. What the new and final procedure across the board is for sending in a plea offer, so there's no confusion about that. Okay.
Number 6, be on time to the hearing. Some of you know who you are routinely late for these hearings, okay, and it's having a negative impact on the rest of our day, and quite frankly, it's inconsiderate. Also, unprepared. If we previously provided you with the documents that we intend to introduce at the hearing, and you want to have them at the hearing, please bring them. I hope, moving forward, we don't want you expecting to get another copy at the hearing, okay? So please continue that.
Or to argue that you're prejudiced by not having it and force us to go to the task of showing the document in which we delivered it to you. This is, again, just a courtesy to those who have come to expect that they will get whatever they need when they get to the hearing. It's not going to continue. That's what they're expecting.
And lastly, this is on hearing continuations. Some of you have come to expect a standard or a routine continuation of the hearing, and I put it in quotes for your words, those are not mine. There's no such thing as a standard or routine continuance, okay? So moving forward, we're going to put forward some reasons for continuations in the future on the website soon, so you can expect that as well. That's really all I have for today.
On continuances, I will say some of the things that I heard were a little surprising to me, even though I understand this is a different scenario than the forums that I'm sure many of you also practice in. Obviously, good cause is good cause, and we are going to try to fashion a group of rules. Look, when I get a new case in civil court, I look at the judge's individual rules for how I deal with continuances. Well, we're going to have something like that too, and we'll put it on the website, and everybody will know what it is, and everybody will know where everybody stands, and hopefully there won't be any confusion. So, with that said, oh yeah, our attorneys are obviously going to follow whatever rules we put in. I mean, I think that's why that benefits you as well, and you will appreciate that. Obviously, there's give and take between lawyers on cases, and I think that to some extent, some give and take that has been given historically or by individuals over time has led to a level of inattention to the ordinary rules that govern lawyer relationships in litigation. And I want to try to kind of correct that direction with some individual and specific rules on some of the things that cause those kinds of conflicts. So with that said, thoughts from the audience, please.
Can we get a consistent fee schedule? I would declare it like really long with like certain fee schedules for certain things. But like, for instance, somebody violating DJ first time could be 1,000 one day, and then I get 10,000 the next time. Can we get a legitimate?
The members can't do that.
So that they have an expectation of what their fine is going to be, because it's not fair. If they're going to violate, let them know that if you violate, you're going to be paying 1,000 the first time, and maybe like we do with the sale to minors, 3,000, 6,000, 9,000, and then you're out.
So they can decide at what point they want to violate and what's worth it to them and not? I mean,
hold on.
So here's the situation, which I don't know that you're really taking into consideration. There is a level of guidance on what the fines are if you don't have a negative record. If you bring someone in that has multiple violations over the course of 2 years or 6 months or 5 years or whatever the case may be, that's why there's a board. At that point, we weigh what that adverse record is, what the activity was that went on, and we agree, at least hopefully two of us agree, on what the fine amount is. So to ask for guidance on that is impossible because it's taken on a case-by-case basis. As far as what the numbers are, such as 3,000 for your first sale to minor, 6,000 for your, I believe that's available on our website.
The only thing that's set in stone are the non-calendar items. Even this idea that a second sale to minor is 6,000, that's just, if you look at the history, that's a traditional penalty. That's not set in stone. The only thing that's definite are the non-calendar items. And that's because over the years we've gone through and figured out these are the routine items. A first-time sale to minor. Depending on if you're a liquor store, the age of the minor, there are variations that are provided for. All right, if you have no history. Right? You're talking about a failure to conform to the application. There are all degrees of failure to conform to the application. So we can't come up with one for that. The ones that are in the non-calendar delegation are ones that, there's some certainty as far as there's a certain set of facts, and we can plug those cases in there. And it expedites the processing of the disciplinary.
I will take from your comment from the audience that what you're looking for is more precision in the offers you're being given on no contest. We will take that under advisement. It's a fair point. I don't think we can be as specific as you'd like.
And also with the 3 zones, excuse me, I'm sorry.
Go ahead.
With the 3 zones, perhaps, while you're trying to review that, because there is a difference. Sometimes another zone, zone 2 may give you some more guidance in terms of what will be considered for an offer. And then you might not get something.
The question that's been asked for those who are on video is, will we consider guidance across zones and try to come up with some consistency? The answer to that is yes. We're certainly looking into that. Yes, go ahead.
I was going to say just the opposite of what was stated. I can't tell you how many times I've called counsel's office and said, look, I'd like to negotiate a settlement. And then I'm told, no, there's a flat line bottom. Now, I'm hearing that there is no flat line bottom, but I'm telling you that they're telling us that they will not go to the board unless there's a certain number, and that's because that's what they were told, or words to that effect. So, I mean, I'd like, because I've done this a couple of times, and I guess my restless ways have gotten me in trouble, but I said, can I speak to your supervisor? No, that's it. It ends with me. So I have a big problem in, number one, asking for a conditional no contest, but assuming I want one, I'm being told a lot, no, we will not.
I don't remember the last time you ever did ask for one.
No, yeah, but I mean, I can tell you one I just now, and I was told, no, I'm not going below a certain number, and I was also told that the reason I'm not going below a certain number is there's a lot of paperwork. In other words, if I go before you and I say I want X, and then you say, no, it's got to be Y, apparently there's a repercussion against that attorney for even suggesting a lower number.
Well, one, before you can answer, but I can guarantee you that there has never been a repercussion or even a comment to any attorney about an offer.
But what happens more times than not?
Well, he's saying there's a new guy here, and he'll take care of what you're talking about, because that should not be happening.
Just to finish that thought, what gives me pause is they said, I will not bring it up unless you put in X. And then, well, once you get in front of the board, maybe you can make some sort of speech that will bring it down. But that gives me a lot of pause. That's why I'm reluctant to do it in the first place. But if not,
I hear what you're saying. I have a few reactions. Number one, the thought that you're going to have an appeal process to talk to somebody else about a plea offer, I will consider that, but I can't see that happening. Hold on. Let me tell you something else.
Okay.
Number two, there may be many reasons why a plea offer is given at a certain level, some of which aren't disclosed to you. I suggest that you not seize so much on what the lawyer happens to be telling you as his reason, which he's probably doing to try to end the conversation with you. He's instructed in a certain way and will be under my leadership as to what offers to make and what offers not to make. And I'm frankly surprised that you're so concerned about the reason why he's telling you he can't get below a number, as opposed to what the number is.
I'm not concerned about the reason. I'm just being told I can't go below that number, period. Let's end the conversation.
Well, and in certain circumstances, that may be the case.
Well, as somebody who was both inside and outside of this organization, I after 45 years, there are very few things I can't survive.
I will take it under advisement. It's a fair point. I will consider it, and I will talk about it.
But just back quickly to that point, there is, other than what Tom described, there is no guidance that the board as a whole or individuals have given the lawyers as to what the offer should be.
I understand.
No, I'm just telling you for everybody, not just you. So whatever this, he's in charge of that, and he'll determine what those are.
But as I just said, what bothers me is in order to get the CNC in front of you, I've got to hit a certain minimum number.
Well, and they probably, to his point, probably said, this is where I'm going, I'm not going any further, and gave you an alternative reason why.
Yeah, the reason is that no.
Well, as we're having difficulty ending this conversation, I can see why they would do that.
Let me go on to another point, because it was stated by Lisa, but I'm not sure that in practice it's done. Yes, if we're not there at 10 o'clock, all hell breaks loose. But if the attorney for the authority starts saying, well, I need the cop, I need this, I need that, there seems to be a lot of leeway the other way. So I would ask that, what's good for the goose is good for the gander as well. If we are...
I think she's talking about people who are habitually late and don't take care to make sure that they're behaving like responsible attorneys before this tribunal. And I'm not talking about latitude on particular circumstances where it would make sense for an ALJ to make a decision about whether to wait or not. So I think the point was a general one.
That brings me to my next point about the ALJ. It seems to me that if you're talking about something like a continuance, and then you're going to set the guidelines, that cuts the independence of the ALJ in terms of, I mean, there may be legitimate reasons.
He's setting them to go through me. So,
but the independence of the ALJ then is somewhat
We are
compromised.
not taking away the independence of the ALJ. We are talking about your request to us for agreement to continuances and issues like that.
Sorry. Then I meant during the course of a hearing, something happens, and then I ask for a continuance. Are you saying that the ALJ is free to say yes or no?
The ALJ will decide what the ALJ wants to decide.
All right, okay, that's refreshing.
it's more, I think more it's geared towards what our lawyers have been agreeing to that they may not be agreeing to anymore, which means that the ALJ is going to have to decide.
No, that's fine, as long as you're telling
All right, then I think we're in agreement.
All right.
Please.
Also, I don't know if this is a problem.
He's older, I'll wait.
No. Article 78, can I discuss Article 78 with you in private, or do you want an open discussion?
That really isn't the subject of what we're talking about right now. So if you want to raise something with me later.
But what it relates to, I had a very recent Article 78 that I commenced, and it dealt with the civil penalty. And I know going back to when I was at the authority would enter into a stipulation saying we'll hold off on the enforcement of the civil penalty until such time as the thing is resolved. You even put into your stipulation that you must bring it to the appellate division by such and such a term, or whatever you want to do. That's been taken away. It adds to a lot of paperwork that has to be done in terms of going to the Supreme Court and going to the appellate division.
Okay, I thank you for bringing that to my attention. That is the kind of thing I would like to talk about. You see a change, you want us to consider it, we will look at it.
So, I mean, I just talked to you.
I don't have an answer for you.
No, I don't expect to answer, but my question is, do I direct these comments to you? Because I do more than Article 78 than anybody else.
You can direct them to me.
Okay, that's it. Thank you.
Please.
My name is Rob Bookman. We haven't met before. Welcome to the Funhouse, Gary. Look forward to working with you. And just a brief comment on some of the excellent points that Lisa raised is that, and we do a lot of CNC. We're the opposite. And that the good-looking young guy who was at the front row, who left before, that was my son Max, who was also disciplinary. But he has come to me from time to time saying, I'm trying to reach this lawyer, whose case it is. I keep getting his voicemail. The hearing's coming closer and closer. We want to enter into conversations for settlement. We don't get a call back sometimes to the day before the hearing. We're now nowhere close to what we had hoped to be, and they're going to oppose, and the counsel and the lawyer says we're going to oppose an adjournment request because it's the day before the hearing. Come to the hearing. So sometimes it's because they're busy, but sometimes it's a tactic, and
how is that a tactic?
It's a tactic because for weeks we haven't prepared the case because we've been hoping to get into a settlement conversation. It's now the day before. Don't have a reasonable settlement conversation. We're now told the day before that we're not in the same room. The reasonable professional thing would be, look, are we trying to reach you for 2 weeks?
I do not consider that a legitimate tactic. I will talk to my team about that.
Neither do I, actually. We want to settle, most of it.
And we don't want to go to hearing if we don't have to.
Once we can't settle, we get to him.
Sometimes the communication problem is on our end. Sorry if I interrupted your.
No, I said once we can't settle, we give to him.
I want you to get as many laughs as you can. So, I don't know enough to know how often it's our fault and how often it's your fault, but I am not naive. I'm sure that there are problems on our side with getting back to people, even in circumstances where the call could have resulted in resolving a case. I will look into it. Seeing no other hands
Anything
raised.
in Albany, Buffalo?
Any questions? Yes, in the other region.
Anybody?
Not about legal. I just have 2 quick questions. Can you tell me currently what renewals are available online?
The only renewals that are available online are for permits, for trucking permits. If you go to our website and
I'm familiar with those. Yeah. Okay. And then I have a quick question about a restroom waiver when there's only one restroom in an establishment. What are the guidelines for the capacity, the occupancy, when a waiver will be granted?
74 or less.
74?
Or less.
7.4. So if it's less than 74, one bathroom waiver is good.
Correct.
That's right.
Thank you.
All right, I want to thank you all. It was wonderful spending the day with you again, as usual. The only thing I can add, we are continue to have an open door policy. If you do, as I said before, if you do have a complex licensing application that you know is coming, one, get to us as quickly as possible, and two, get it in as quickly as possible, obviously. We are working on this issue daily, and I agree with Mr. Bookman. We recognize this as a crisis, and I'm here to fix it, and I think everybody else is as well. We want to be part of the solution, as I'm sure you all do too. So thank you all.
Thank you.